like to call the Physician Assistant Board to order. Today is August 18th, and we are meeting in Sacramento. First item of business will be roll call. Anita?
Charles Alexander.
Here.
Michael Bishop.
Here.
Christina Gomez Vidal Diaz.
Present.
Sonia Early.
Here.
Jed Brandt.
Here.
Catherine Hazelton.
Here.
Xavier Martinez.
Here.
Robert Sachs.
Here.
Rosalie Shorter.
Here.
All right, we have a full quorum. Very good. At this time, I'd like to introduce Anita Winslow. She was selected as a candidate to fill our staff services analyst position, which was vacated by Lynn Forsythe, who became a licensing associate government program analyst. Anita has worked in a number of capacities at the medical board since 2012, and prior to working at the medical board, she worked for the Secretary of State's office for 3 years. So welcome to the PA board.
Thank you.
Okay, next item of business will be approval of the May 19th minutes. Do I have a motion?
So moved.
A second?
Second.
Okay, further discussion? Everybody happy with them? Okay, all those in favor of accepting the May 19th, 2014 minutes, say aye.
Aye.
Aye. Opposed? All right, the minutes carry. Item number 4, the board may not discuss or take action on any matter raised during public comment section that is not included on this agenda, except to decide whether to place the matter on an agenda for a future meeting. Public comment? All right, next item of business is President's Report. I attended the Founding Advisory Committee meeting of the new PA program in Fullerton, Marshall Ketchum University. They were recently approved by the ARC. They will be taking their first class end of August, beginning of September. Of note, the ARC found no deficiencies when they did their review, which is an outstanding performance of the staff who set up the program. Teresa Thetford, unfortunately, at that meeting resigned. She's been traveling from home in Connecticut to Fullerton, and finally decided that she needed to stay in Connecticut, so they have replaced her with a new individual. It's going to be a great program, 24 students. And that concludes the President's report. Public comment? Glenn?
I'd like to update you on Breeze. We're continuing to have production stabilization issues with the program. Mainly our issue now is with reports, so we're working with the department to resolve that issue. Our licensing program is functioning appropriately, and we aren't experiencing any delays with the Breeze licensing. I'd also like to tell you that both Diane and Lynn are attending license and enforcement user group meetings on a regular basis, and this is assisting us in resolving a lot of the issues that we have that we share with other boards, so that I'd like to thank them for attending those meetings because it's been very helpful to us. I'd also like to thank the staff of the Medical Board of California Information Systems Branch. They have been assisting us as well. They have a great deal of knowledge with the Breeze system, so they've been really taking the time to help us and answer a lot of our questions, and they are looking out after us, so I'd like to thank the staff for that assistance. And also, thanks again to the staff for taking care of Breeze and getting us on board, and so we can get things working. Any questions on Breeze? The next thing I'd like to talk about is the Cures update. Work on this program continues. The feasibility studies report has been signed and approved by the Department of Consumer Affairs as well as Department of Justice. Also, the department and the 10 boards that are going to be using the CURE system have chosen representatives of the Joint Executive Steering Committee. And Kim Kirkmeyer, EO for the medical board, is representing the prescribing boards, and Virginia Harold is representing the dispensing boards. And the department, Tracy Ryan, is representing the department. They've also started what they call joint application development sessions. And in those sessions, the various boards talk to the vendor and talk about what we need on our system, and so they can implement that into the new program. So that's where that's at right now. Are there any questions about the CURE's system?
When do our licensees start paying the fees?
They have started paying the fees as of the April renewals. So that's and it's $12. It's $6 every year. So it's for biennial renewal, they're paying $12. And that concludes my report.
Okay, next will be licensing. Lynn.
Good morning. Initial licenses that have been issued from May 1st of this year to August 1st of this year is 256. And as of August 1st of 2014, we have a total of 9,540 licensees. That's the end of my report.
Cool. We're approaching the magic number there at 10,000. Okay, diversion activity report, Lynn.
Okay, as of the 1st of July, we have a total of 13 participants in the program, consisting of 3 voluntary referrals and 10 board referrals. We've had a total of 124 individuals participating in the program since 1990. I'd also like to let you know that Maximus was again awarded the contract for the diversion program. It's for 5 years, commencing January 1st to 2015 to December 31st to 2019. The cost increase for participant has gone up to $338.15. It's currently about $306, so it went up about $32. And as you're aware, our program participants pay the entire amount. If it's a board referral, it's the entire amount. And if they are self-referrals, they pay 75% of that fee. Any questions on diversion?
Glenn, I noticed was as of July 2012, was that a abnormally high number? Because if not, it seems like things have dropped off a bit in the next couple of years. Is there any rationale for that? I'm just curious, just a curious number.
The numbers have dropped off because the participants have to pay the entire amount.
Is that
so
right?
We find that most self-referrals will probably go elsewhere. Maybe I think today as well, health plans cover a lot of this. Oftentimes we'll have a self-referral that'll go in advance of a disciplinary action. Perhaps their attorneys have said you might want to go in. That might help with your case. But we predicted that generally with the increase in the fee, that it would probably discourage self-referrals from enrolling in the program.
So unfortunately, behavior isn't improving. Just shifting things. All right, thank you.
Okay. Any public comment on any of the executive officers' reports? Okay. Next item will be Diane Schuster, the enforcement program.
Good morning. As Glenn indicated, we're still working on trying to get the Breeze reports fixed. So what you have before you is another sort of abbreviated report that I keep. So, okay, under disciplinary decisions, we denied 2 licenses. We placed 6 people on probation, issued 1 public reprimand. We revoked 7 licenses, 8 licensees surrendered. We issued 10 probationary licenses, denied 1 petition for reinstatement, and 2 termination of probation. For accusations, we filed 19. We filed 2 statement of issues, withdrew 2 statement of issues. We filed 1 petition to revoke probation and issued 3 PC-23s or interim suspension orders. Citations, we issued 19, closed 9, we have 12 pending, and we've received $4,100 towards the fines. And probationers, we have 47 that are active and 13 that are polled. Somebody have any questions?
Do we have any way of knowing the aging of the cases, or is that lost in breeze?
That's part of the breeze. So
Okay.
that's.
Public comment? Okay, thank you.
All right, thank you.
Okay, next item on the agenda will be Christine Lally, the Deputy Director, will talk to us.
Good morning. Is this on? Yeah, there we go. Good morning, Christine Lally, Deputy Director for Board and Bureau Relations with the Department of Consumer Affairs. Always a pleasure to be with you. Just wanted to check in on one of the biggest changes to the department this summer, and probably the most exciting change. We had a change in leadership just last month, and we said a tearful goodbye to our director, Denise Brown, who served the department for over 30 years. And we welcomed Awit Kadani, who was previously the Chief Deputy Director, so you probably recognize his name. So now he is the director of the department. And then we also welcomed Tracy Ryan, who was previously our Deputy for Legislation. She is now Chief Deputy of the department. So it's been a fairly smooth transition, because obviously we're well aware of the skill and experience of Awit and Tracy. And in the coming months, we look to set up meetings with all of the executive officers. So we'll be reaching out to you, Glenn, to have a sit down and just to check in, how the department can better serve the board. So we'll be doing that here shortly. And then also another item I just wanted to check in on. I was talking to Dr. Sachs about reappointments. And we have a few members on the board who have terms that expire coming in January 2015. So this would be the time to put your application in if you are interested in reappointment. It's a good time. The year is almost up. Hard to believe. And so you definitely need to put forth your interest in reappointment. So if there's any help that I can give in that area, please don't hesitate to reach out. So, short and sweet. Any questions from the board, or anything that I can help the board with, let me know.
I think it's great. I think this is the first time in many years that we've had a full 9 members on the board.
I'm going to keep it that way.
No quorum issues. Well, thank you.
Good, thank
I
you.
know you have a very busy day, so.
Oh, you as well. Thank
Okay.
you.
All right, next item on the agenda, regulations, proposed regulation amendments to Title 16 of the California Code 1399, 541, medical services performable. Item A is our personal presence regulation, which has had 2 15-day public comment periods, one to change or, and one to change a couple of other clarifications of immediately available. It had 15-day hearings, medical board, then I guess we approved it first, and then medical board approved it. And it is now with the Department of Consumer Affairs, and once they sign off on it, hopefully it will go to the Office of Administrative Law. That will have 30 days to decide whether they like it or not. So we're in hope that this regulation passes. It will make significant improvements in the way a physician assistant is supervised in surgery. Any questions on the regulation? Okay. Public comment? Okay. Item B will be Mr. Mitchell.
The Department of Consumer Affairs recently transitioned the processing of the sponsored free healthcare events sponsoring entity form to the complaint resolution program. Therefore, we had to update our regulation to reflect the new form, which was recently revised, and we do that via what is called a Section 100 change, and it's a change without regulatory effect. We did submit that package to the Office of Administrative Law on July the 8th, and it was approved by the Office of Administrative Law on August the 13th of 2014. So we have updated, we'll update our regulation to reflect that change in the form. Any questions?
Public comment? Okay, moving right along. Next item is going to be from our attorney, Christy Schellen. And this is discussion of board members reporting alleged violations of physician assistant laws and regulations to the board.
Okay, so I was requested to speak to this issue. During this discussion, I would appreciate if the members refrain from discussing any fact patterns or anything that might come before the board at a later date. So please don't give me any hypotheticals grounded in fact, or name any names or anything like that if you have questions. But the physician assistant laws do not contain any requirement that a licensee or a board member report any suspected violations. There are some boards within the department, for example, respiratory care therapists, licensed vocational nurses, or psychiatric technicians, that do have actual requirements in their statutes that if a licensee has knowledge that another person may be in violation of or has violated any of the statutes or regulations administered by those boards, the licensee has to report this information to the board in writing and shall cooperate with the board in furnishing information or assistance as may be required. That is from the Respiratory Care Board's laws at 3758.5 of the Business and Professions Code. So if you had some requirement like that one, then yes, there would be a legal requirement they report it to the board. It's really up to your discretion, judgment, and internal compass, I guess, whether you want to report something. It would be reported as a complaint like any other complaint to the board would be investigated. But there is no legal requirement in your Practice Act that needs to be a report to the board. Any questions?
Should we create a regulation?
Well, I mean, this is your call with respect to whether you want to set policy in this area if you think it's an important issue. As I've stated, there are other boards that do have such reporting requirements, and it's really a matter of policy whether you want to make it a requirement. I know attorneys have to if they observe, professional violations of professional standards, and you're supposed to report it to the bar, but it's really a policy call for this board. Any interest?
I just think that it puts a board member in an awkward position when they become aware of something that is illegal or improper, that there's no requirement to report, so they're aware of it, but they're not reporting it. It's almost like they're hiding it. Or if there were to be a bad outcome later and it became clear that the board member knew that this illegal activity was occurring and didn't report it, it could reflect poorly on the board or the board member. And so for that reason, I think maybe we should consider a policy saying that when we become aware of something, a board member becomes aware of something, that they should consider reporting that. That's just my feeling, is that if we have that requirement, it provides a protection to the board members should they become aware of something.
Further discussion?
Yeah, I would kind of take, although I agree ethically with you 100%, Jed, I just worry about potential retaliation against a board member by the workplace or by the environment in which they work were they to report something. I think everyone has to balance out in their life, as you said, your internal compass and the consequences, unless there was some sort of a specific language in the regulation that would provide immunity / protection against retaliation. I'd be concerned about that, having seen it in the past, that whistleblowers are given immunity for a reason, because they have in the past been seriously retaliated against. So I think we have to be mindful of that as we go forward, but ethically, 100% behind you.
My concern is that I'm sorry. If you rely on someone's morals or internal compass, that history is rife with examples of that failing.
And I do want to mention that one of my concerns would be when you attend conferences and people have approached you and asked for clarification and you become aware of situations, which I'm sure has probably happened when you've traveled to a couple of conferences and given your presentation on regulations, and someone will say, I've never operated under X, Y, Z, then would you be obligated to report that because you've just become aware of it? So I'm wondering in your capacity how that would affect you.
Well, I mean, when I have given talks in the past, there's always a confessional at the end of the talk that takes place. And I give them my opinion, and I emphasize that. And most of them have pertained to individuals who are students who are thinking about licensing. And my credo to them has always been, write everything down, even if you think it doesn't matter, because on your application we will find out. And that's pretty much the way I've handled it in the past. I appreciate Christie's comments.
Well, I think if they're going to ask you about whether you think there's a violation in a particular case, you stay away from that, because what happens is if you give your personal opinion and it later comes as a case before the board, you have to recuse yourself, plus you may make yourself a witness in your own case, because maybe you give them advice that's not supported by the statutes or your expert or something, and then they have you subpoenaed to testify as to your opinion regarding whether somebody violated. So my advice is always to tell them that if they have a question about compliance, they need to refer it to the board, and the board will address it with them. And that way you're not put in a position of giving your opinion about compliance or not compliance with the law. And I know I usually tell my clients to write when they ask for what I call advisory letters, that you decline to do that sort of thing, because sometimes people don't give you all the facts and you give them an opinion and they try to use that to excuse or mitigate their conduct going forward. So just going forward, as a general rule, I kind of advise against giving opinions about, can I do X, Y, and Z under the physician assistant law? I would kind of stay away from that in general, even without any kind of rule or reporting requirement or anything like that. So.
Okay. Any comments down on this side? Okay. Would it be appropriate to just refer them to the executive officer?
Yes, I think that would be appropriate.
Okay.
So I guess I don't, so if a board member is aware of a violation and they're not required to report it, it's just left up to their discretion whether or not they report this violation.
Right, but with what you said, I think you make some valid points. I mean, if you're the enforcement body for the state and you're on that board and it comes to the public's attention that you didn't do anything with the information, it could look badly on, for you. And you have to think about that, and also if you're a governor's appointee, if it gets back to the governor, you may not like that too much. So, I mean, there are political considerations, there are moral considerations, there are ethical considerations, but legally, if you're asking me if there's a straight up requirement, the answer is no. So, but those things that you've raised are valid considerations, and also complaints that are filed are privileged from disclosure, so you have to think about the fact that the staff's going to handle complaints confidentially, and there may be a point where you'd be asked to testify, but I think for the most part, just getting the information to the board is a key consideration. The board handles things confidentially. There's a privilege attached to filing complaints. There's a privilege from complaints for defamation and that sort of thing, because you're making a complaint to the agency who's a privilege against those kinds of communications being used against you. Now, you know, your comfort level in reporting it and the impetus behind it, I really can't, because there's no legal requirement. I can't say whether you should or shouldn't. It's just going to be a judgment call for you.
Okay, thank you.
Further comment?
Well,
Catherine?
the one comment I would make here is, I mean, I can really see both sides of this. I think that to some extent it feels like the board is or board members are condoning certain behavior if it's not reported, which seems really problematic. But on the other hand, it also seems problematic in particular for the PA members of the board to potentially be liable for presenting all of this information to the board when there are sticky situations, when perhaps they may not realize that something is a violation. There are all sorts of potential liabilities that seem problematic. It may also discourage people from serving on the board because they don't want to be in a position like that. I wonder if there's a way for us to encourage board members to share this information without necessarily requiring it per regulation. If it's something that is in our training as board members or guidance that's given to board members that there's a certain expectation that information would be shared with the board.
Do you have a policy manual? You might want to consider amending your manual, and you could bring that back to the board at a future meeting date for changes and updates to the manual, and put that in as a guidance to future members or current members.
I think it's really healthy and helpful for us to have this conversation and to, for us to have a sense of whether this is an expectation or not, and for everyone to have some sense of agreement without necessarily a requirement that would place PA board members in particular in a tough position.
I have a question. If someone from the board filed a complaint, are you saying that they may be called in to testify at a later date?
Yes, that's always a possibility. It depends on the type of information and for instance, like people complain about sexual misconduct. It's kind of hard to prove a charge if the victim is not willing to testify against the respondent. So it just depends on the type of violation, whether it can be validated externally some other way, or whether we actually need that testimony to prove the case. So it just depends on the type of violation.
So then what position is the board member placed if he or she has to give public testimony?
Well,
And if he didn't, or she didn't, and someone said you knew about it, why didn't you report it?
Well, I mean, they would certainly, if they testify, they would not be sitting and making a decision. And, there's options for delegating decisions to administrative law judges and the APA if you have to, because there may be a concern about there being a bias because the other members know the member. So we'd have to look at those options for a case. Of course, the board would have to agree to do that, but I think that the APA has, the Administrative Procedure Act, has options for dealing with that sort of situation. But yes, I mean, the thing I'm not sure if the complaint form says this, but some of the complaint forms I've seen say that we may need your testimony or something, so that people are on kind of notice that they may be needed or called upon, and then they can think about it before they file the complaint.
Okay, thank you.
Further comment? Public comment. So maybe on the next agenda, we're consider creating a policy.
Well, you might want to bring back your manual for review and maybe consider adding this to the manual.
Okay.
And that would be on an agenda for a future item for discussion.
All right. Sounds reasonable. Okay. We'll go on to item 9, which is discussion of approved controlled substance education courses, responsibilities of the course provider. This has to do with the drug course, which is given in order to qualify for physician assistants not to have the pre-approved prescription by the supervising physician. And I'm just wondering what our responsibilities as a board is pertaining to auditing the various education courses to make sure that they are complying with the regulation.
Can you give us a little bit of history? Because I obviously wasn't on the board when all this came about. Did we create this and then the courses were created out of what the board?
Yes, basically, it was actually legislation that the California Academy of Physician Assistants sponsored, which was AB 3, 5, 6 years ago, which basically, if you took the drug course, then you no longer had to get pre-approval from a supervising physician for a controlled substance. The legislation was passed. We then, as a board, had to create a regulation which basically outlined what the requirements of the course were and the amount of time that the course would take. We had a subcommittee that worked on this, and ultimately the regulation was passed. It's essentially an 8-hour course, which includes lunchtime. They have to take an examination at the end of the course. The course is only open to licensed physician assistants. So you cannot be a student and take the course. You have to be graduated, have taken the NCCPA boards, and be licensed. My concern is that maybe some of the individuals that are taking this course are not licensed PAs as yet.
So besides CAPA administering these courses, is there any other entity that does it?
Yes, there is. I believe the Stanford program is also administering the examination. So it's just, right now they're out there and nobody is looking at the results, and something that this board is responsible for, or if it's okay just to let it go the way it's been. Refer to my attorney.
Okay. So Business and Professions Code Section 3502.1C2 states that the physician assistant has to complete the education course that covers controlled substances. So obviously, someone that's not a physician assistant, licensed as a physician assistant, shouldn't be taking this class before they're actually licensed, and for it to count, so to speak. And so if you look at the regulations, 1399.610B and 1399.612B, regarding the certificates of completion and requirements that the course provide a comprehensive written examination, and that the licensee must successfully complete the examination to receive a certificate of completion. Certainly within the regulatory language, you can see that the emphasis is that the person has to be a licensee, and the board has authority at 13.612 to audit essentially the courses, and the course provider's required to make the records available to the board upon request, and one of the records that has to be made available is the certificate of completion that includes the name and license number of the physician assistant. So to me, that would be how you would check to make sure that they didn't issue or train someone that wasn't licensed as a physician assistant take that course.
Well, that's what I'm wondering. I mean, when you register, you have to give them your license number anyway. So, but we haven't audited any of these two programs at all in the 6 years since. So, I mean, maybe that is a good start, and then we can decide if there's enough information or if people are slipping through the cracks. I mean, I imagine that at Stanford, it's probably people who graduated from there, or is it open to the public?
I don't know. They just, I believe, recently within the last year started doing the course. CAPA has done it since the inception of the regulation, but it was just something that I thought we needed to look at because we created the regulation, but we haven't followed up on any
question. Does the board maintain any record of licensees who have taken the course, or is that only maintained with the provider of the course?
I think it's only maintained with the providers. We have no,
We have no records or documentation. They take.
As part, perhaps noted on their licensure or something like that, so that there's not this compliance issue?
I don't know if that would be a good idea, because I think not everybody's gonna be prescribing controlled substances, so you may get more information than you need. And I think the focus is on compliance with the provider, and the provider has all the records available, which can be audited in order to ensure that they're following through on the requirements and that they can still be recognized by the board. So to me, that's really what makes sense, and otherwise you're gonna get a lot of pieces of paper, and I'm not sure what you would do with that information.
And could it be an underground regulation if we're mandating they report that?
Well, I mean, you'd have to change your renewal requirements and reporting requirements, and you have a list of things that have to be reported in regulation right now. You'd have to add that to the list of things that are reported, and I mean, it's up to you if you want to handle it that way, or, to me, it just makes more sense to just review the practices, because then you'd know whether they were.
I understand. The reason I'm asking is because as PAs change jobs, each employer they go to, they're going to have to provide this certificate. If it were somehow noted on the license or a box checked when renewing the license, have you had this course, yes or no? Perhaps it would be something that could be noted by the board when the license is checked to see that they've had the course, instead of having to reprove it every time they change jobs or work for someone else. That's the only reason I'm asking. It's easily verifiable by the public and employers that the PA has been certified to not get patient-specific authorization prior to controlled substances.
But then your staff would have to validate every one of those to make sure that they actually took the class. Because some people check that they've done all their CE, for instance, and we found that they have not.
Right.
So.
But now you have no one checking and no one validating, except perhaps employers if they're savvy enough to do it, or the PA themselves. So, just a question.
I have a question. Is there some way that we can, with all the new systems that we have going up, is there some way we can add that to the new electronic system?
I don't think Breeze we could get that in there.
Well,
Isn't
not
every
Breeze,
form said-
maybe the new, when we recertify or update,
That's, the Breeze
The
system
Breeze.
is doing all
Okay.
that, and unfortunately, the forms, I think they're cut off at this point, right, Glenn, is that right? So we're kind of stuck in terms of being able to expand what we put in the form. Right now, we have to do a separate mail out for this, if you wanted to do this part, but that would be, we have to bring this back as another agenda item, but, we can certainly explore that, but it would definitely be a separate mail out, because the fact that
right.
we're kind of hamstrung with the way that things are playing out right now with Breeze. And they required, I think, the form changes to be in, was it last year, or, yeah, so, they're not accepting new form changes right now.
But would we have to do a regulation change prior to asking that question?
Yes.
Okay, so that would be.
It would be a couple years from now.
but we could audit the course providers now.
Yes.
But that's in the regulation.
Correct.
Okay. And the other part of this regulation is that you don't have to take this course if you don't want to have the patient-specific drug order. So not every PA is going to necessarily take the course. So.
Or you could take the course and your physician doesn't want to waive that requirement.
Right. Further discussion? Public comment? Okay.
I'd like to make a motion to do an audit.
I'll second that.
And for what period of time would you like the audit?
I think we should go back, I mean, it's only been 6 years, how cumbersome is that to require, is it best just to do a 2-year period, or?
It's up to the board.
Well, and what exactly are we auditing for? Are we gonna look at the course content and then the number of people taking it? I mean,
At this point, I think we're gonna do an audit of who is actually taking the exam, and to ensure that they have an actual license number, to make sure that they were actually licensed physician assistants when they took the course, correct?
that seems like it wouldn't be very hard to do.
I think it would be good to know, one of the requirements is the requirements for the individuals that are actually giving the course, if they have the appropriate training to be speaking on what they're talking about. I think
So are you looking at like a statistically significant sampling of, in terms of the audit, or are you
Well, I
looking
think-
for everything?
I think they could provide, the course providers could provide us with copies of their syllabus that would have probably the curriculum vitae of the individuals that are giving the course, which would give us a better idea of what their qualifications are, and then potentially maybe 6 months of individuals who have taken the course. I don't think it needs to be a long period of time, it just needs to be a spot check every couple of years to make sure that the providers are in accordance with all of the regulations. Right now, we have no idea. Public comment?
CAPA provides this course probably 4 times a year now. We were doing it much more often in the beginning. So it's not, if you did a 6-month period, there may or may not be a course in that 6-month period. There is a new provider that's only been doing it for about a year, so I'm not sure how that would happen. With regard to licensing, and Glenn and his staff can tell you when there's a CAPA controlled substances course, their phone rings off the hook, because people want that license, because we're adamant that, I mean, anybody can take the course. You don't even have to be a PA. If you want to come, pay your tuition and take the course, that's okay. But for that course to count, our interpretation is for that course to count toward the ones in your career time, you have to have a license at the time you took the course. So the PAB does everything they can to expedite those licenses. We have, if the license, if someone from the PAB says your license, the course is Saturday and we're going to issue your license on Monday or Tuesday, I don't know what day you issue them.
Right.
We have been known with a note from Glenn or a call to say, take it, we know your license is going to be issued on Tuesday. So I don't know what we're going to say about that, but the point is that the day they took their course, the license was imminent. So if you audited those records from 3 years ago from someone that took the course, of course they have a license today, but the day they sat in that classroom, did they have a license? I think is the question.
So what would the board like to do with this, if anything?
Yeah, I would amend that motion to being a year period, because I believe that would capture at least the cycle of the 4 classes for CAPA, and then potentially the year of the new license, or the new provider.
Who's the second?
Second.
Are you okay with that amendment?
I'm fine. Does this include, so just to be clear, we're talking about taking a look at their syllabus and make sure the syllabus and the credentials fit the criteria set out in legislation, and then we would check also a year's worth of participants. Is that correct?
Yeah,
That
I think that'd be reasonable.
would that be terribly onerous on staff?
No.
Okay, do we need a formal motion?
Yeah, they have first and second
Yeah.
already.
Okay, sorry.
That's
couldn't hear
okay.
it. Further discussion?
I have a question. I'm wondering, well, the extent of what we're asking staff to do are those 2 questions that we just proposed. Do we want to also give staff the flexibility to ask other questions as as this audit is being developed, there may be, another reasonable question or two to ask at the same time for efficiency purposes. Perhaps staff working with our chair may determine to add additional questions or inquiries.
Glenn, is that something you would agree with?
Sure, yes, I agree with that.
And not a recommendation that you add additional questions, but the flexibility to do so,
Sure.
if so determined.
I'd like
Further
to amend
discussion?
my motion to add that flexibility.
Okay.
And I'll second that again.
Public comment? All those in favor, say aye.
Aye.
Opposed? Abstain? Motion carries. All right, at this time, we will take about a 5 to 10 minute break to allow for setting up for our hearings, which are going to start at around 10 o'clock. Thank you. Yes, so I will call the Physician Assistant Board back to order and turn the proceedings over to Judge Karen Brandt, Administrative Law Judge.
Good morning. We are on the record before the Physician Assistant Board of the Medical Board of California of the Department of Consumer Affairs of the State of California in the matter of 2 petitions this morning. The first one will be the petition for early termination of probation of Robert Lucas, case number 950-2014-000189, OAH number 2014-070057. And then we'll have our second petition after that, the petition for reinstatement from surrendered license of Ricky Hicks, case number 950-2014-000124, OAH number 2014-070052. My name is Karen Brandt. I'm the administrative law judge who has been assigned to preside over this matter. To ensure that we have a quorum, I'm going to ask every member of the board to identify themselves, starting first with the member on my furthest right.
Sonia Early.
Catherine Hazelton.
Rosalie Shorter.
Charles Alexander.
Robert South.
Michael Bishop.
Jed Grant.
Xavier Martinez.
Christina Gomez-Vidal-Diaz.
There is a quorum. Next, I'm going to ask first Ms. O'Carroll to make a presentation. Would you like to identify yourself for the record?
Good morning. I'm Megan O'Carroll of the California Attorney General's Office on behalf of the Attorney General.
And we have Mr. Robert Lucas here representing himself today.
Yes.
All right. Before we went on the record, I explained a little bit about the procedures in this matter. Ms. O'Carroll will go first to make a presentation of the case and to present the exhibits. You may proceed.
We're here today on Mr. Lucas's petition for early termination of probation, the probation that he entered into upon stipulation in case number 1E 2009-198587. I have provided a copy of exhibits, which you should find in front of you. And actually, I have the original copies here with wet signatures, so I may just change these two. And Exhibit 1 is a copy of the Certificate of Licensure for Mr. Lucas. And Exhibit 2 then is a copy of the certified decision of stipulated settlement and disciplinary order in the 2009 case. And then this is Mr. Lucas's second petition for termination of probation. So Exhibit 3, you'll see the decision in the earlier matter decided on January 17, 2014, and that was in case 1E in 2013-23376. Finally, as Exhibit 4, you'll see the petition for penalty relief, Mr. Lucas's petition, in which he's seeking early termination of probation. That was submitted on March 8 of 2014. The attachments to the petition are listed here. These are all documents that Mr. Lucas submitted, and the Attorney General's Office stipulates to the introduction of all of those exhibits. And then finally, it's not listed on your packet, but I have here, you've already had an opportunity to see the investigative packet concerning the early termination petition for early termination of probation. The substance of this document indicates essentially that Mr. Lucas has complied with the terms of probation and that there have not been any new violations of law. The exhibits to this are listed in the final page, and some of those attachments will naturally not be immediately following this packet because they are instead in front of you for ease of reference. For example, the certified copy of the decision I've taken out and put as Exhibit 2, so that you'll have the underlying case disciplinary record immediately in front of you. So let me just, and then after the hearing, Mr. Lucas and I, before the hearing, went through and made sure that there were no confidential information like date of birth or social security. All that had been redacted from Exhibits 1 through 4. But immediately after the hearing, for this final exhibit, the petition for early termination investigative report, Mr. Lucas and I would like to just go through it and make sure there's nothing that needs to be redacted before we submit it finally.
All right, I've marked for identification as Exhibits 1 through 5 all of the exhibits just identified by Ms. O'Carroll. Mr. Lucas, you have no objection to all of these coming into the record?
That's correct.
Exhibits 1 through 5 are in evidence.
In considering the merits of this petition for early termination of probation, the board will have various factors to consider that you're all familiar with, specifically the activities of Mr. Lucas since the disciplinary action was taken, next the offense, the underlying offense for which he was disciplined, as well as his activities during the time he was in good standing, and finally his professional ability. However, regardless and apart from all of that, if the board considers that there remains a danger to the public from early termination of probation, then that should outweigh all of the other considerations. And with that, I would allow the board to begin.
Thank you. Mr. Lucas, it's now your opportunity to put on your case. If you would stand, I will swear you in. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Would you please be seated? And as I stated to you at the beginning of the hearing, the board has already seen your petition package, so there's no reason to repeat everything that's in it, but the board is most interested in hearing about your rehabilitation to ensure that if your petition were granted, there would be no risk to the public posed.
Thank you, Judge Grant. At first, I'd like to apologize for my attire. I left my garment bag in my car at the airport in my airport of origination, so I was actually shopping for a jacket this morning, but no place was open. I'd like to thank the board for their service to the medical community in the state of California. I'm on a board myself for the our area, the central office of AA, where we help our local meetings. I also contribute to the newsletter there, and I know it's not all glory. My application is unchanged except for the update with regard to the previous decision. I was not aware that while criminal probation was ongoing that I didn't qualify for early termination. I learned that when I got the decision. And I noticed when I filled out the new application this time that they added a question about that. So I applaud whoever does that job for updating that to help that not happen in the future. You have my application and the previous decision, all the evidence that I provided before that. One thing that has changed in this year is that one of the doctors that I work with, Dr. Chopra, gets a lot of referrals for bilateral mastectomy and immediate reconstruction, which has really upped the amount of hospital cases we do. And so that's where my presence in the operating room is most missed, is I can't go to Cedars-Sinai because I can't get privileges there while on probation. One very busy practice has started referring us these cases. A lot of people get this operation now prophylactically based upon genetic information, and the doctors have to hire a physician to assist them where I really take the place of the physician and I'm already on salary. One thing I'd like to point out in the letter of opposition, that is, you know, I would regard this and try to straighten it out as far as it not being correct. It talks about how a reason for early termination is not my financial gain. To be doing these cases at the hospital, I'm a salaried employee, and there's no profit motive for me. I just want to do my entire job for the practice. And so the practice is suffering, but obviously it's not going to make or break them. It's just that I've either been monitored on probation or in diversion or sober, all those for 6 years. I got sober without being disciplined and was sober for a year, and then began the testing through Maximus after a year. It took 2 years from then to be offered this stipulated agreement. And when phone conversations were going back and forth, I represented those 2 years of really satisfying the terms of a probation with regular testing and mandatory meetings and things. And you know, I was just told that, well, that doesn't count. But I really think it should. You know, if I was satisfying the terms of probation anti-grade for 2 years, if you consider that, it's been 5 years of monitored time, which I think demonstrates to the public and to the board that my administrative sobriety extends beyond the term of probation. So there's not really a magic number. You know, they call long-term sobriety 5 years. All of my sponsors and my friends, you know, I tend to pal around with people with 20 to 45 years. Long-term sobriety is possible even without monitoring and probationary things. I have a lot of friends in AA with long-term sobriety, and I emulate them. That's what I've learned to do, is to be of service to the fellowship and to my fellows, especially newcomers. One example of that is my participation in a health support group, which is part of the Maximus program. I was a participant. I continue to go just voluntarily, and I serve as a replacement facilitator for that group when the facilitator can't do it. And that's something I'm uniquely qualified to do, because a lot of healthcare professionals, you know, in these 12-step programs, we say you can't be too stupid to get this thing, but you can be too smart. And a lot of people, there's denial to get through. When they see me, that I've been through it and I've come through the other side, and I still go, that's an example, like the example that I see from the guys with 45 years. That's an example of what to do. You know, what you got to do is, for long-term sobriety, peace of mind, for serenity, you've got to continue to do this practice. The disease of alcoholism is like the disease of diabetes. It requires constant treatment, and if you abort treatment, you suffer the symptoms. And I don't do this because I'm being tested, and I don't do this because I'm on probation. I do it because I appreciate the life I have. I wouldn't go back to my old life if I could, because I'm way happier now. And I know that the only thing that leads me back to chaos and disruption of my life and, you know, betrayal of everything I love now, the only thing that takes me back there is old behaviors. So I don't do those things. I do these new things, and I've got a freedom I never had. I did a long distance swim race. I didn't really know how to swim a few years ago, but I said, let me do this. Somebody kind of challenged me to do it, and you know, that's the sort of thing I do now. You know, it's not just about recovery, it's about life. I think I'm a better father, a better employee, and I would like to in the future. I'm preparing a presentation for the AAPA to speak at annual meetings with regard to recovery, diversion, probation, etc. I would like to give a talk, and maybe somebody there will hear me, or maybe I'll just be a cautionary tale for people. But no matter what, it's a continued effort to be of service
And I look forward to that opportunity to get afforded to me. I've done similar things, and then I helped give a mini academy to board investigators 2 years ago. And I did that with a facilitator, Joyce Francis, who's an addiction facilitator. And that was very rewarding. So I'd like to continue to do those things. I think if I'm afforded early termination of probation, I think it would be appropriate. I don't feel like I'm any risk to anybody now, and I aspire to not be a risk to anybody in the future. I think it would be a nice kind of closing point if I got, in what's in my mind, fair treatment. In this case, at the end, I think that if you do what you do, if you do the right thing and you continue to do the right thing, good things should happen. And I think that it would be good if this happens for me. However, if it doesn't, I'm still going to do what I do, and I'm just going to accept it, because acceptance is a big part of sobriety. So I thank you for listening, and I thank you for this second hearing. Thanks.
So Carol, any questions?
One question that comes to mind, Mr. Lucas, is that in each of the 2 DUI incidents in which you were arrested, I noticed the record indicated there was above a .08 alcohol consumption. Were you also using any form of non-prescribed drugs or street drugs at that time?
I don't know. I have never done street drugs except for in college. I used a little bit of marijuana. I think everybody was doing it. I didn't like it. It made me go to sleep and I couldn't study, so I stopped doing it, and I never really tried it after college. As far as prescription drugs, there have been times during my life where I have absconded with a pill or 2 when it was possible. I'm sure that I have taken them over the course of years, but I don't know, and I don't believe there's any evidence that I was using them then. When you're an active alcoholic, you do all kinds of things that you wouldn't do normally. I can also say I've never done anything like that since. One last point, I will admit, I don't want to be a member of the public to stand up and involve myself in your hearings, but I heard a conversation about whether people should be compelled to report things, and I feel like I'm one of those people that's compelled to report for moral reasons, my moral compass. If I ever saw anything like that, or if there was any evidence of it, I would be one of the type of people to do it not just for the rightness of it, but for the person who's doing what they shouldn't be doing. I got stopped by the police, and that was part of my recovery. That was my, pulling out of a nosedive and heading upward again. And that's something I would consider carrying the message forward to another person. I would help someone get busted, because I think that ultimately, not only for the public, it also serves that person. So to directly answer your question, I could say I don't know.
I guess what I'm really trying to get at is, was your addiction problem a disorder? Was it based on alcohol, really, or was it like a polysubstance issue involving drugs and alcohol?
It was alcohol, and I've never had a drug problem, but I would emphasize, and I think that probably most of the board knows this, it's all one disease. I mean, some people manifest it in shopping, buying, relationships, sex. The disease of alcoholism the disease of addiction takes many forms. The treatment is all kind of the same. I understand that there are legal differences between one thing and another, but the cure is also the same. When you look at 12-step programs, they all originate from the original one, but there's many of them that treat many things, but they all really work on the same principles. And so while the question, I get it, as a recovered alcoholic, I could say that in a way it's not, it kind of doesn't matter. But the other thing, I just let the word recovered slip, and I know it's become politically correct to say recovering. In the Big Book of Alcoholics, it says recovered in the first 160 pages approximately 38 times. It doesn't say recovering but once or twice. And, you know, there is such a thing as recovered. You can be recovered from the pitiful and incomprehensible demoralization of addiction and alcoholism. But to be recovered, it takes doing the sort of things that I do.
And how long a period of time would you say that you suffered alcoholism?
There's some invisible line that gets crossed. I was drinking too much in the 90s, and I moderated my behavior, and then I was a steady drinker. I'm Irish. My father was definitely an alcoholic. My older brother is definitely an alcoholic. It's a family disease. So when I developed it, is really unknown. I can say that I've definitely driven while intoxicated more than twice. I mean, if you can imagine, what's the chance that the only 2 times you ever did it, you got stopped by the police. So my life was unmanageable, certainly for probably the calendar year going into my big decline. I was drinking more and more heavily. I had a period of isolation. I was apart from my family. I was in California, they were in Connecticut. So it was a combination of having the disease of alcoholism and having the environment in which it can blossom and kind of explode. And another point that's not in these papers is that I have a very good, stable home life. And you know, I have a place to go back to, I have a place to be all the time. And you know, I'm really nervous now, although I have no reason to be, because like I said, I'll be okay no matter, you know, what the decision of the board is. But go on.
And you're now, am I correct, you're no longer on any kind of required monitoring or probation or testing of any sort, is that correct?
Well, I'm on probation with the board here, and I do mandatory testing. Okay. I check in every day, and if you don't check in, it's not a good thing. I checked in every day faithfully for years, since I started Maximus 5 years ago. So, yeah, I mean, I am on probation here, and I test. The Connecticut and New York probations are a result of the probation here, but there's not testing for them. They just require that I satisfy California's requirements.
Did your criminal probation require testing as well?
No, it didn't. It had stipulations like if you have any measurable alcohol when you're driving, you know, that's a violation. There were just a few things, but they were really meek. You know, the medical probation that I've been on far exceeds the requirements of the criminal side.
I have no further questions. All right. Questions from the board, starting first with President Sachs.
Okay, yes, good afternoon, Mr. Lucas, or this morning. Were you employed by Cedars at the time of the original discipline?
No, my physicians have, I work in a private plastic surgery practice, and the 2 physicians I work for have privileges at Cedars, and they have for years. It's the uptick is mostly the last year, but before that they've always done maybe a dozen cases there each a year, and for which I've been absent. I haven't been that missed until this last 2 years, because this is when the bigger cases have started coming. You know, I think that earlier they knew that I was on probation, it was going to be a while. But once I told them that I qualified for applying for early termination, they requested me to do so they can have my help.
Okay. Now, when you originally signed the stipulation, you realized that it was going to be a 4-year probation, correct?
I understood it was a 4-year probation, and that early termination was possible after 2 years.
That's all my questions.
All right. Any questions from Member Early?
Yes. I just want to make sure I have all the timelines correct. So the initial incident occurred in 2008. Approximately did you start the first Maximus 1 year after?
Yeah, I got sober. I haven't had a drink since I left jail from the second DUI.
Okay.
Or anything else.
And you mentioned that you were monitored then?
No, I wasn't monitored that first year.
Okay.
So that's why I could say that I've got over 6 years of sobriety, and over 5 years of it is what you would call administrative sobriety.
Okay, all right. And then you started the Maximus program.
Yeah, after a year, the board sent letters and asked what's going on with this conviction, and I talked to Jim Tracy, who's a friend that I know from my involvement in fellowship, and he encouraged me to enroll in Maximus.
Okay, and then we have that since 2009.
Yes.
Right. Okay, great, thank you.
Member Hazelton?
No, thank you.
Member Shorter?
No, thank you.
Member Alexander?
Nothing to.
Dr. Bishop?
Yes, Mr. Lucas, you said, it's been an argument here from the DAG that this is especially for convenience, that this early termination, at least that's one of the thrusts I see here. And of course, I'm really concerned about our service to consumers. Certainly we want to protect their safety, but on the other hand, we want to provide services in an efficient fashion for our consumers as well. Is the absence of your presence in the OR, does that cause delays in scheduling of cases or longer times in the OR for the patients? Is there any negative consequences for our consumers, our patients, because of your absence?
Prolonged operating room time. Even when the doctors hire another surgeon, you would think that that would be superior to a physician assistant, but in my experience, or at least in my practice, it's not. I substantially reduced the operating room time because of my abilities. I mirror the surgeon on lots of the procedure. In other words, things are happening on the right and left at the same time. Particularly the closure, which in plastic surgery can be the majority of the case. So I would say longer anesthesia times, harder on the surgeon. He might book one case in a day instead of two. I think that would be the majority of it.
Thank you very much.
Member Grant?
Yes, I have one question. In your statement you said you implied something about unfairness, or in the interest of fairness, that you're here. Could you explain that? I missed what was unfair.
Well, there's 2 years when I was in Maximus, fulfilling beyond the requirements of this probation, and there's not any credit kind of for time served. If you look in other areas of the law, if someone were incarcerated and then they were convicted of something, they would be given credit for the time that they spent incarcerated awaiting trial. In other words, I voluntarily submitted myself, yet there's not a reward if the full term of probation is enforced. So, I would say based upon my case, another third person could look at it and say, well, I might as well wait till they tell me I've got it, because there's no reason to go in early, because your time is going to be the same no matter what. And this is something I didn't want to bring up. I brought it up last time, but your question kind of requires that I answer it as this. When I say that I understood that I had 2 years of probation, that I could apply for early termination in 2, through a conversation that I had with the Attorney General's office, my understanding was that if you had perfect compliance or good compliance, that was, I can't quote it because I don't remember the conversation, but it was very likely. And I have learned since then, through being in a recovery environment with other clinicians, that it's rare. So when I agreed to a 4-year probation, I was thinking 2, and then some process to get out. Had I thought that it was rare, I might have tried to get something less. And I didn't, because of the conversation that I had. Now, none of that's on the record, and I don't have any evidence of it. But it seems fair that if that sort of conversation is going to occur, then people should be honorable, or at least representing the reality of this process for what it really is, which is those requirements that were read about, what it takes to get early termination of probation. It's not just compliance. It's other factors. So had I understood that, I might have done something differently. However, like I said, I'm here, I'm happy, I'm a content person with peace of mind, so whatever it took to get here, you know, is all right. I probably wouldn't have enjoyed, you know, having a battle and the stress of that either. I got to focus on my recovery by just acquiescing and signing the stipulated agreement. So it's got its positive side too.
Thank you.
Member Martinez?
No questions.
Member Diaz?
No questions.
Any further questions from any members of the board? Any further questions that you had, Ms. O'Carroll? Would you like to make a summing up?
Yes, Your Honor. In considering the factors that the board has to consider in making this decision, the activities that the petitioner has taken since the disciplinary action are commendable. So often you see people trying to obtain an early termination of probation, and all that they have to say for themselves is, well, I did everything I was supposed to. In this case, Mr. Lucas has taken steps to really improve his life and his situation, and as he said, he has worked with the medical board to provide training and understanding, and as you see, there is the letter from Laura Sweet acknowledging his behavior and his contribution. However, another important thing for the board to consider is the underlying offense, as well as his activities during the time his license was in good standing. In this case, the underlying offense, which is 2 DUIs within a very short time period of each other, about 20 or 22 days, as Mr. Lucas himself acknowledges, that's not something that just happens out of nowhere. It comes from history and time before that of having a serious addiction. And that necessarily, by definition, represents a potential threat to the public. So it's up to the board to determine whether or not that risk is outweighed by the benefit of the actions that Mr. Lucas has taken since that time, as well as his evidence of rehabilitation. The tipping factor, and the reason that the Attorney General's office argues against termination of early probation in this case, is that Mr. Lucas did have a prior, this is not the only instance of discipline that Mr. Lucas has had. It is in California. However, in Connecticut, he had an incident where he was placed on probation for 6 months and fined $5,000 for exceeding the rules governing what physician's assistants are permitted to do in Connecticut. And that is in the package that the board has in the attachments, Exhibit 4, the attachments. And so that would contribute to condition number 3, the conditions of the activities of the petitioner during the time the license was in good standing. Again, it is the board's decision as to whether or not these factors warrant continuing probation. And as the board was considering, there are probation restrictions which will necessarily have an impact on the public. And the question the board has to decide then is, will these necessary restrictions and the effect they're going to have on the consuming public of medical treatment, will that be more worthwhile or less worthwhile to continue probation and to protect the public more, but then also risk not having the ability to have Mr. Lucas participate and in the practice as fully as he would otherwise. And with that, I would support.
Thank you. Mr. Lucas is summing up.
Well, I would say that I would love to be of service to the board in the future if there was any way that you saw that I could help. If anybody ever showed at my office wanting me to pee in a cup, I would always say yes. I just would like the actually being on probation to be over so that I can fully commit to the practice that we have. A mid-2000s episode of disciplinary action in Connecticut was just brought up, and I don't know if you'll have time to read through the whole file. I would like to explain that if I have a moment. Do I have a moment? I mean, I don't want to get into a 20-minute thing, but...
Yes, you have a moment. You may do so.
A moment I'll take. That's got nothing to do with substances or alcohol or anything. The supervision in Connecticut, the statute about it was on the vague side. And I used to believe that vague statute was good because then you can interpret it to your liking as long as your interpretation was reasonable. I thought that was a good thing. It turns out that vague statute isn't great. I think California statute is way better than Connecticut statute. That case represents an example of a political football game being played where I was the football, and I got the book thrown at me with regard to doing Botox in a medical spa situation. The concept of medical spas was really new back then. The Connecticut statute said part of supervision of a PA is being in contact by radio, telephone, or other telecommunications, and that implies to me that the physician need not be present. It says later in the statute, with regard to a physician in a hospital who supervises more than 2 PAs, because 2 PAs is private practice. So television, radio, and telephone is for private practice with up to 2 PAs. But a physician can supervise as many physician assistants as medically appropriate under the circumstances, provided that the supervision is active and direct in the specific location at which the physician assistant is practicing. The board looked at that sentence fragment of the statute and applied it to a private practice setting, which I thought was erroneous. A former president of the AAPA who testified for me thought it was wrong. The sitting president of the Connecticut Academy of Physician Assistants thought it was wrong, and I had those 2 gentlemen as expert witnesses, but I still lost the case, and I did change my behavior, lest you observe me as somebody who does what he wants with no regard and then repeats these offenses. Not long ago, within a couple months, another physician asked the board to look into me again in Connecticut. And that's what it tends to be, is competitive physicians that become aware that you're busy in practice, make a complaint. And the state of Connecticut looked at it and saw good enough compliance in my behavior that they dismissed it without going further. So I do the appropriate thing now. If I have evidence that I should change my behavior, I change my behavior, and it stays changed. And my history demonstrates that.
Anything further?
Just want to thank you all again.
Any further questions from any member of the board?
I have one last question.
You may ask.
In the event that your probation is granted or lifted, what would you do differently, or would you change anything at this point?
I wouldn't change anything about my life. I would go directly to Cedars-Sinai and reactivate my application. I think everything else would stay exactly the same. It'll feel weird not checking in, to First Labs every day. And I think I'll be able to, with a little bit of happiness and pride, represent, this journey as being, at least administratively, a complete journey to other alcoholics. But also at the same time emphasize, just through my behavior, that hey, here, look at me, I'm still doing these same things. I don't have to do anything, but I'm still doing these same things because that's what you need to be sober. So to be a power of example to other alcoholics would be my continued goal.
Thank you.
Anything further from any member of the board? Anything further, Ms. O'Carroll?
I'm not sure, have we moved to introduce into evidence the exhibits that were previously marked?
Yes, all of the exhibits are in evidence.
That I have them.
All right, we'll go off the record at this time to switch to our second petitioner. Thank you so very much. We are off the record. Does anyone need a break or anything in between? we are back on the record after our break. While we were off the record, Ms. O'Carroll brought to my attention that in our prior petition hearing with regard to Mr. Lucas, we had not marked and identified and admitted into the record the written arguments from both the parties. So I've marked for identification as Exhibit 6 Ms. O'Carroll's written argument, and I've marked for identification as Exhibit 7 Mr. Lucas's written argument. And as I understand it, Ms. O'Carroll, you're asking that we admit both of these documents into the record?
Yes, Your Honor.
And Mr. Lucas, you agree with that?
Yes.
Thank you. Both Exhibits 6 and 7 are admitted into the record for Mr. Lucas's case. And once again, we are off the record for Mr. Lucas's case, and we are on the record for Mr. Hicks. And Mr. Hicks is now in front of us. And you were here and present for the earlier hearing? All right. We are now on the case of the petition for reinstatement from surrendered license of Ricky Hicks. And we have a full quorum of the board present. Ms. O'Carroll, you may proceed.
This is the petition by Mr. Former Physician's Assistant Ricky Hicks for a reinstatement of Physician Assistant License 12721. Before you, you have a packet of exhibits. Included as Exhibit 1 is the certificate of showing a surrendered license of Mr. Hicks.
Ms. O'Carroll, did you give me a copy of this package?
I have the original.
I will let you describe that if you'd like to do those.
I have actually here.
Thank you.
And Exhibit 2 is a certified copy of the decision and order and stipulated surrender of license in case number 1E1999-104764. In this case, Mr. Hicks stipulated to the surrender of his license following a proceeding in which he was charged in an accusation with violation of various criminal and business and professions code statutes based upon an event that occurred in California and a criminal case for insurance fraud. In this case, Mr. Hicks was charged in Los Angeles Superior Court with Medi-Cal fraud and with creating false records of patients. He was convicted upon jury trial of each of these counts as well as of grand theft. Following this, he was charged with these convictions as well as with the underlying conduct in the accusation. He stipulated to the surrender of his license, and this became effective in the stipulated order went into effect on September 11, 2002. Exhibit 3 is Mr. Hicks' petition for penalty relief seeking reinstatement. He submitted this on January 7, 2004. It contains a series of attachments, including his narrative statement and letters of recommendations from 3 physicians, as well as several continuing education documents, his resume, and a driving record. I believe Mr. Hicks also has with him some continuing medical education information and certificates that he would like to add as part of the record. Perhaps we can do that when we get to the end of the exhibits, rather than add them as Exhibit 3, because then it won't be complete.
That will be fine. Do you have enough copies for everyone?
Unfortunately, I do not. I only made 4. It was an oversight. I did this at the last minute.
Do we have someone here who can make copies for everyone? Yes. Thank you. If you could just give those, thank you so much. You may proceed.
And then we have as Exhibit 4 certified copies of court documents. These were submitted to the board by Mr. Hicks, and they show the record of the case of the Los Angeles Superior Court
his criminal case, People of the State of California versus Ricky Hicks. It shows that he was found guilty after a jury trial on 7 counts, 5 of them being insurance fraud counts, and 1 of them being a grand theft count. He has also provided information showing that he subsequently achieved a dismissal under Penal Code Section 1203.4, indicating that he had not committed any previous offenses following that the conviction, and therefore he was able to obtain the 1203.4 relief. And then as Exhibit 5, this is the exhibit that Mr. Hicks and I would like to take a few minutes at the conclusion of the hearing to make sure everything is redacted. It contains the investigative report on the probation, showing that Mr. Hicks has been in compliance with probation. And then you'll also notice that in that particular document, the board has already received it, but there were several attachments to it. Some of these attachments, again, I've taken and separated out and put, for example, Exhibit 2, the certified copy of the decision and order. So if you see any missing attachments for that investigative report, that would be the reason why. And then finally, we will, well, not finally, but next, Exhibit 5 will be the written...
Exhibit 6.
Okay. Exhibit 6 will be the written opposition of the Attorney General to the petition for reinstatement. And then Mr. Hicks also submitted written argument that the board should have. I will find a copy of that and we can move to introduce that as Exhibit 7. Mr. Hicks, do you have a copy of the written argument that you submitted to the board?
Not with me today.
Okay, I'll locate that. And then we'll also get a copy of your continuing education documents. Do you have those? Should Mr. Hicks provide copies to you now?
I believe that he has in fact provided copies and they have been so graciously made for us. Thank you. If you want to bring those forward. Mr. Hicks, I have been given a 3-page document that is a certification and recertification exam review, a National Healthcare Association Certified Medical Assistant certificate, and then a third letter dated September 26, 2003. I gather attaching the certificate, or are these the 3 pages you wanted to make part of the record?
Yes, Your Honor.
All right, I'm marking this document as Exhibit 8. And any objections? Ms. O'Carroll?
No, Your Honor.
Okay, that is made part of the record as well. And those shall be given to all the board members. The copy I have, so Carol, is that your copy? I have a second copy of it?
Oh, that's okay. Okay.
And do I have a copy of your written argument?
I believe you do, and we're still looking for a copy of Mr. Hicks' written argument.
Thank you.
Do you want me to just make copies of this one?
Mr. Hicks, did you submit a copy of the written argument?
I attached it.
Is it a 1 page?
No, it's multiple pages.
Let's go off the record while we find that. We are off the record.
Yeah.
We have copies.
You do, okay.
Yeah, I don't believe Mr. Hicks was aware to serve the Attorney General's office with a copy of his written argument.
We all received a copy. Do I have to make copies?
Oh, that would be great.
That would be wonderful. I need one as well.
You might check and see if that's truly.
Yeah, is this the, remember when you received
Yeah, that's it. That
from
is
the
it.
board
Yes.
saying to serve like 10 copies?
Yes, ma'am.
This was it, okay.
Do you need more copies?
Yeah.
Who doesn't have one?
Actually, I think it's just me and Judge Brandt. We don't.
Okay. Do we need to wait on that, or shall we go forward?
I'm prepared to go forward.
Let's go back on the record. We are back on the record after our break. We are still waiting for an additional copy of Exhibit 7, which is Mr. Hicks's written argument. All the rest of the exhibits are present, and Ms. O'Carroll, I understand you're offering them into evidence?
Yes, Your Honor.
And Mr. Hicks, any objection?
No, ma'am.
Exhibits 1 through 8 are made part of the record. You may proceed.
The Attorney General's office has submitted all of the documents in support of the petition and would reserve argument.
Mr. Hicks, it is now your opportunity to put on your case. If you would please rise, I will swear you in. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Would you please be seated? And what the board is most interested in hearing about is all of the rehabilitation you may have engaged in order to establish that it would not be contrary to the public health, safety, and welfare to grant your petition. You may proceed.
Thank you. I'd like to thank the court for allowing me the opportunity to give cause for reinstatement for my physician assistant and privileges. I'm requesting that I be allowed a pathway in restoring my physician assistant license. I've completed the petition process, provided my written argument for reinstatement, and I feel I deserve a second chance. In 2002, I was convicted for grand theft and insurance fraud because I knowingly allowed patients to use medical insurance cards that were not their own, and I created false records in order to provide medical care to them. There's no excuse for what I did. I was wrong. I used very poor judgment, and I'm very sorry for what occurred. I'm still extremely ashamed and embarrassed by my actions, and I've worked hard to move beyond those poor choices and to rebuild my life and career. I successfully completed the terms and conditions of my sentencing and probation, and I've not had any further troubles with the law. I've paid all the fines and penalties associated with my probation and restitution. I filed for and have been granted an expungement of this conviction from my record. I have worked through the obstacles caused by my wrongdoing in hopes to receive a second chance to work as a physician assistant. With a felony conviction on my record, I was unable to work in my chosen career as a physician assistant, yet I spent 30 plus years of my life studying or working in medically related disciplines. I entered the medical field in 1979 as a licensed vocational nurse, and now I'm a clinical instructor for medical assistant students at Virginia College in Greenville, South Carolina. The period immediately after the conviction, I needed to help provide a living for my late wife and our 2 boys. This was very difficult because of the 12 previous years, my primary income was obtained from my work as a physician assistant, which up to this point I've been unable to do because of the conviction. My wife was also a physician assistant, and during this period she was the major income earner of our household. However, I still needed to be productive and responsible for myself and my family. One of the ways I earned money was by opening a fast food restaurant. Also during that time, I had a business selling nutritional products and supplements to private individuals and to physicians. While doing that, I had the opportunity to help doctors to develop marketing strategies for weight control programs in their clinics. I also acted as a liaison between the doctor and their weight control patients in providing nutritional education and moral support. Since 2008, I've been an instructor for medical assistant students. My duties have involved teaching the students all aspects involved in daily management operations of a doctor's office. Our curriculum teaches the students about diseases, how to perform vital signs, how to give injections, about medical and surgical aseptic techniques, anatomy and physiology, making appointments and referrals, filing, maintaining electronic records.
If you're going to read it, our court reporter, yes, needs to.
Or would you like me to begin?
The list.
Okay, our curriculum teaches the students about diseases, how to perform vital signs, how to give injections, about medical and surgical aseptic techniques, anatomy and physiology, making appointments and referrals, filing, maintaining electronic records, and many other aspects of assisting in the medical office. One of the conditions of my employment was that I had to pass the national exam to become a certified medical assistant. I successfully passed the exam, and I was only given a 2-day window to prepare for it. I credit passing that exam to my ongoing exposure and studies involving medical disciplines. I've continuously stayed involved in some aspect of keeping current my skill set that I've been taught for being a primary care provider. I've done this by participating in continuing medical education seminars, reading journals, having informal discussions with professionals in the medical field, and by being the primary caregiver to my late wife as she battled cancer. Before my wife's death, and while she was an inpatient at MD Anderson Hospital in Houston, Texas, I was allowed to make decisions involving her care plan, was taught how to care for her PICC line central catheter in which she received chemotherapy, and spent countless hours educating myself about leukemia. Most recently, I have completed a 43-hour physician assistant national certification examination preparation seminar to provide me with an extensive overview of primary care medicine and allow me a greater probability of passing the board exam should I be allowed to sit for it. I have not had any organic or chemically induced mental or physical condition which would have diminished my capacity to perform as a physician assistant. Furthermore, I have constantly made myself available to help others. This is part of my personality and it's always been that way. Currently, I provide volunteer services for Mental Health America of Greenville, South Carolina. I work their crises hotline calls and provide active listening techniques and resource information to individuals that are having mental breakdowns or that are in need of assistance due to being battered or homeless. I also volunteer for church ministries and recently participated in the Serve Our City Day hosted by the church I attend, where we volunteers go out throughout the city, painting, cutting grass, and cleaning, among other needed services. Serving is a big part of who I am, and I have often been a help to others my entire life. Lastly, I have been working to remain a positive example to my son and to my family members. My responsibility to my sons is expected. However, in light of my wife's death and having an autistic son diagnosed with cerebral palsy, I want to be able to provide for them the best of my abilities and my capabilities. I've been through a lot and I know what it means to be responsible for my actions. I believe I have sincerely done the things in my power to restore my life and career. I'm asking for a second chance. And I will continue to make a positive, proactive step to being a law-abiding, productive citizen, as well as a competent medical professional given the chance. Thank you for your consideration.
Thank you. Ms. O'Carroll. And this is Exhibit 7?
Yes, Your Honor.
Thank you so much.
Mr. Hicks, where is it that you're currently residing?
Greenville, South Carolina.
And do you have any intention of returning to live in California?
At this point, I don't have any. I don't know what I'm going to do at this point. I don't know if I am or not.
If you were to be required to be on probation with the California Physician Assistant Committee, would you be in California and practicing here?
Yes. However, I read in the case, I guess, the law about stipulations that The exam that we take is a national exam, board exam, and any stipulations that would be imposed upon me could be done anywhere in the United States of America.
For the last, since the date of surrendering your California physician's assistant license, where have you primarily been residing, or have you been moving back and forth?
No, actually, I've been residing in California. I moved to South Carolina. It had a lot to do with my wife's illness.
And what year was it then that you moved to South Carolina?
October 2012.
And your children also reside now in South Carolina?
That's correct.
The letters of recommendation that you have attached, the first two from Dr. Albury and Dr. Maziki Kelly, if I'm saying that correctly.
And if you could spell those for our court reporter, please.
Albury is A-L-B-U-R-Y, and then Dr. Maziki Kelly, M-A-Z-E-K-E -K-E-L-L-E-Y. And actually, am I pronouncing that name correctly?
No.
Okay, can you tell us how to pronounce it?
Denise Aubrey and Mazik Kelly.
Thank you. Dr. Albury and Dr. Mazik Kelly, how do you know them?
Dr. Aubrey, I've actually done work with her. She's actually helped me along with the nutritional part of my business when I was doing that, and I've also assisted her in some of the things in her practice. Mazik Kelly is a lifelong friend of my late wife.
Were either of these two physicians, were they ever your supervising physician?
No, ma'am.
Do either of them, did they have experience of observing you while you were practicing? Like, were they in a similar practice to yours?
Well, no. In general, no, because I was not allowed to practice when I was working with Dr. Aubrey. But you know, my skills were, even though I wasn't allowed to practice, I still possess my skill set that I've learned. And Dr. Mazik Kelly, we've just basically discussed cases and things like that. She's never actually saw me work. But also, I want to submit that I think if you're not a supervising physician, you won't be afforded that opportunity to really see a person actually work. If you're not involved with the patient that they're giving care to. So I don't know if that bears any weight of what the inference is.
With relation to the criminal case in Los Angeles County in 2001, were you arrested and booked into county jail for that offense?
At some point I was.
Had you ever been arrested prior to that date?
I have been arrested.
What was the date and the reason for that?
I don't actually recall the date. I know that the date was 10 plus years or you know, I know it was, I was very young when that happened, and that case, I was caught with a firearm.
Okay. Where what kind of firearm?
A gun.
Handgun?
Yes.
And whereabout did that occur?
In Los Angeles.
Were charges filed based upon that?
The case is vague. I just remember the conviction.
Did you have to participate in any kind of probation or pay a fine or anything related to that?
I don't recall, but I don't believe I did.
And how long ago was that?
It had to be about 25 years ago. Or maybe even longer than that. I think maybe even, I'm thinking it was actually even before, had to be before I even became a vocational nurse, so it probably was prior to 1979.
Was that in Los Angeles County?
Yeah.
Aside from those two incidents, have you ever been arrested at any other time?
No, ma'am.
Going to the facts of what led up to the case in 2001, did you have a supervising physician at the time that you were alleged to have committed the fraud regarding the patient files?
Clarence Sutton was the supervising physician.
I'm sorry, I didn't hear that. Could you?
Clarence Sutton,
Sutton?
that's correct.
And do you know whether or not he had any kind of a disciplinary case for the incident?
I do not.
Were you ever interviewed or investigated or called to testify in anything relating to him?
No, ma'am.
And now you've described the incident as it occurred as being that you were having kind of community health fairs. Is that correct?
That's correct.
About how many people would participate, like how many patients would participate in these kinds of events?
Actually, it's very vague. I don't remember. And also, I would like to submit to the court that I'd like the record to stand. It is documented, that case. That is, I'm admitting my wrongdoing in that case. I do not wish to relive it. I've actually done everything I can to remove myself away from that incident. I'm not trying to minimize it. I'm just not trying to wallow in it as well. I don't want to.
So are you indicating that you're declining to answer questions about the
No,
event?
no, ma'am. No, ma'am. I just actually want the court to allow the record to stand, the record to speak for itself.
So approximately then how many patients would participate in these fairs on average?
It actually was something that was going on. It had a start and a finish. So in the beginning, there was smaller numbers than in the beginning. It was something that had to be advertised or marketed in a way, and so it definitely varied. I don't recall the amount of patients, but sometimes I would see maybe 30 plus patients, and it would be over a 12-hour period.
And you indicated there was a time when these began and when they ended. Can you give us approximate dates as to when these started and when it stopped?
It was about, I would say maybe a 5-month period, and that was somewhere around 2000.
And was your supervising physician aware that these events were taking place? Do you know?
Yes.
And how ultimately did this incident, how did it come to the attention of law enforcement?
I don't recall. I mean, not, I don't recall, I don't know how that came about.
Did law enforcement come to interview you and talk to you, or were you just arrested?
No, actually, I believe there was an investigating agent from the board, the medical board, and no, I was never arrested. I was arrested, I guess, after the court conviction. That's when I was actually arrested.
Okay. As to the court proceedings, were you represented during these proceedings? Did you have an attorney?
I did have an attorney. The representation was not what I would deem actually good representation, but in the end, it was actually, I mean, the right thing occurred. So I think, you know, my thinking at that time was totally wrong. And
when you say you're thinking at the time, are you referring to during the course of the court proceedings?
well, just I guess my impression at that time was that I wouldn't be I wouldn't get into trouble because, you know, I was turning my head and letting people use cards, which of course is ridiculous. So
are you suggesting that the way these events occurred and the criminal conviction ultimately was arrived at was based on the fact that people were presenting you with false cards?
No, I'm saying that my thinking at that time was off base and I was wrong in the way I was thinking.
Some of the patients that were referenced in the accusation that you're ultimately charged with by the Physician's Assistant Committee, they indicate courses of treatment for patients that would not, like assuming they were actual, well, first of all, let me ask you, were the patients referenced in the complaint actual patients that you saw?
Yes, I mean, they were, I saw people that had active cards.
In looking at some of those records, they indicate medical decision-making that you stipulated was inappropriate from a medical point of view, like totally irrespective of whether that was the actual person, whether the insurance was a valid card. But for example, there were indications where there were patients who had very high blood sugar levels and yet no further follow-up was done with reference to their potential diabetic condition. Can you explain how that came to be?
Well, actually, when I'm looking at it from this viewpoint, I was actually going to different areas that were underserved, projects, things like that. And it was, you know, the people that were using cards were basically seeking care at that time. Follow-up was almost impossible because of the nature of what was going on. It was just a very bad situation. You know, it ended up being a very bad situation. It wasn't my intent to actually go out there and defraud the state. However, it did wind up that way. I was just, you know, my thinking at that time was just totally off base, and I just think that I've tried since that point to remove myself from that and rebuild my life.
Amongst the number of patients that were seen, the accusation lists out a few, I think there are 6, in which it points out things like, for example, high blood pressure screenings showing high blood pressure but no follow-up, or high blood sugar and no follow-up. Do you think that that was the exceptions to the number of patients that you saw, or was that pretty much the rule?
Actually, just again, when we're considering the type of patients that I'm seeing that are using cards that are not correct, you know, you wouldn't expect them to actually come for a follow-up or actually be a patient that actually is going to be doing what is the normal nature of a patient physician assistant doctor's relationship. So in that sense, I think what you're alluding to is that the care was inappropriate. However, I believe the whole operation in that sense was inappropriate. I did see families and individuals that were who they said they are. However, that's not why I'm in court today. And so the point being that in answering those questions, I wouldn't expect someone that actually is not representing themselves to actually follow up like a normal patient would.
Okay, so I guess the question I'm trying to ask you is, although we have instances here where it shows inadequate medical care, do you feel that by and large the treatment that you were providing at these fairs was, for the majority of patients, was it good care?
I think in most cases it was appropriate care. Again, for these particular cases that we're talking about, I agree that that was inappropriate care. But I think you're bringing up the points of continuously following a patient, and I'm not sure that patients that want to be seen and receive whatever care that I was giving at the time would want to be seen on a continuous basis.
So are you suggesting that you would identify certain patients that you didn't expect to follow up, and you would run tests that were not required or put in bills for Medicare that you knew that they would not challenge?
At that time, I was actually what I guess my mindset was that if someone had an active medical card, that I would treat.
And for the people who did not have active medical cards,
I would not treat.
would you submit bills for them anyway, even though you did not treat them?
I wasn't really a part of the billing thing, so I guess there was a certain device that would be able to tell if the card was active or not, and if it was active, I would treat.
Are any of those patients represented in the ones listed in the accusation?
I don't have any knowledge of that. I don't know.
For the patients that you ultimately stipulated to that you had provided inappropriate medical care, and did you submit documents for Medi-Cal reimbursement with the knowledge that they would be reimbursed and the knowledge that those bills were not appropriate and true?
I wasn't really responsible for billing. I would treat patients by seeing them, making a medical record for them, and then submitting a super bill in my chart. And that's how that process worked.
So what was it that you did then that caused you to be convicted of fraud?
I knowingly allowed patients to use insurance cards that did not belong to them, and I created false records.
Were you required to pay a restitution amount based on these activities?
I was.
What was the amount of that restitution?
I actually don't remember, but it was somewhere in the thousands. I mean, somewhere near. I remember paying a sum of, like, after my probation or whatever, $20,000 or $18,000, something like that.
And how was that amount determined?
I have no idea.
Was it based on billings that were submitted to the insurance company?
I have no idea.
Was there evidence about that submitted at the jury trial?
I don't recall.
I have no further questions.
All right. How about some questions from our panel members? Let's start first with President Sachs.
Yes, hi, good morning. I noticed you have not been certified since 1997, which was before all of this has occurred. And you provided us with a document today saying that you've taken a review course in April. Do you think it would have been a wise thing to have taken the national exam before you appeared here?
I won't be able to sit unless I'm have reinstatement. That's my understanding.
Okay. And do you know, did you have significant financial gain from these incidents that have been discussed today personally?
No, sir.
Okay. That's all the questions I have.
Member Early.
Yes, I have a few questions. Good morning.
Good morning.
You mentioned about 25 years ago you were living in Los Angeles where you felt that you needed to carry a handgun for protection. What neighborhood in Los Angeles were you living in?
I grew up in greater Los Angeles. I was, a black young man growing up in Los Angeles, and with just with all the things going on, I got into some trouble and things like that, and I would go into trouble areas, and I carried a weapon because of this. At that time, I felt that it would help me protect myself.
Great. I have a couple other questions. I think you alluded to some of them regarding were you performing your own medical coding? I think you mentioned that you weren't doing your own medical coding.
No, ma'am.
Okay. So you had a medical coder that was going through and...
That's correct.
Okay. And then also you mentioned that you didn't know if Dr. Sutton had any disciplinary action.
I don't know. Actually, after after everything came to light, what was going on, he disassociated himself with me. So we really never really talked after that. Okay. I think his attorney advised him not to talk to me. I was trying to reach out to him and explain what was going on, and he hadn't. But
how long did you work for him after that? You didn't.
That was the period that I worked for him.
Okay, and then when you were performing the medical fairs, were you under his supervision?
Yes.
And did he ever go to those fairs with you?
No.
And from that point, you would do your, so when you talk about the ID card, are you talking about the Medi-Cal card?
Yes, ma'am.
Okay. And then there was some person there that was trying to, or certify that it was working or not working?
It had a little device that you could run the card and you can see if it's active or not.
Okay, and then once they were active, you performed the physical examination and the laboratory test?
Yes. I would.
Okay, and then if they weren't active, you didn't see them?
I guess they were turned away.
They were turned away. Okay, great. Thank you so much.
Member Hazelton.
Hi. We appreciate the detail you've provided. I'm wondering if you could tell us a bit about your, we understand that the fairs that you were providing. Could you tell us a bit about the rest of your practice as you were practicing as a PA, the type of practice in which you participated, your role in that practice, the length of the practice?
For the most part, I was in family practice. I was actually a partner in a corporation for about 7 years. And kind of what was going on at that time was kind of a perfect storm to get me into the trouble that I got into. The businesses that we were providing, or the services that we were providing, were going quite well. But around that time is when the whole landscape of insurance was changing towards managed care. Before it was an individual was allowed to go to whatever doctor they wanted to, and then when managed care came, patients began to be rolled into programs, and as doctors that weren't involved in the managed care part of it, the HMO had to do certain things to qualify to do those. So to be a part of that, and I was a partner with a physician by the name of Raymond Greer, and many of our patients were being rolled over, and he wasn't really wanting to actually do the things that were needed to become a participant in the HMO program. And there were a lot of not only license, thresholds that you had to do, but also there was physical things that had to happen to your facility in order to actually be a part of that. And then at that time, it was very new what was going on. So when we sat down and looked at actually what needed to be done and the amount of income that he would actually receive from it, he didn't really want to be involving himself with that. So what happened is a lot of the patients that were our normal patients, where I was just actually being in my own business, were going to other doctors, and we weren't allowed to actually make the money that we needed to keep the doors open. So eventually that business had to fold, and then that's when I started to actually go into the health fairs, and I approached Dr. Sutton to see if we could do that, because that way we could actually go out, and the people that had active cards or whatever, we would be able to see those people that we would be reimbursed for, that were not in or had been enrolled in the HMO program with the provider.
Thank you. Can you provide for us any evidence of the quality of your work as a PA?
Well, I guess no. I would have to say the only evidence I would say for that is that I had to pass a national exam to get my license, and then I also recertified. I believe that was in 1997. I had to recertify, which I passed that test. And so other than that, I would have to say that I have as much proof as anyone else that practices. Yeah, that's.
Thank you. And you mentioned that your relationship with Dr. Sutton is no longer. I'm curious if there are any other physicians who supervised you during your time practicing as a PA, and if so, why we didn't receive any materials from any of them.
I'm not really in contact with the doctors that I guess were supervising. I've lost contact with them. Yeah, I don't really, I didn't have a relationship that I guess after our business was through, that was kind of it. We weren't like in contact at all.
Okay, thank you. And a final question about the various patients that were in your original court case, and the billing codes there. I was just a little bit confused about. I know you had a coder. Were you surprised by the codes that were listed, or were these things that these various tests, were these things that you were indicating to your biller that you were performing?
Actually, I really that part of it, I really did not invest a lot of time investigating which codes were used or whatever. There was a protocol that I was following. And I would actually, when I would see the patients, I would actually just mark off a super bill of the things that were performed or what I said that I performed, and submit those into the biller. So I wasn't really, I wasn't involved in the billing part of the business. I was actually just involved in actually seeing the patients.
But it's your understanding that you indicated that these tests that were listed here were performed by you.
Right.
Okay, thank you.
You're welcome.
Member Shorter?
So I guess I have a similar question about the billing. So you're saying that you would submit the super bill based off of your exam, and then that would get changed before it was submitted or added to?
No. I would mark off, like routinely mark off things that we were supposed to do that I was supposed to do while I was seeing the patient. So I would just mark boxes of what I would do, of what I was, like, I guess there were routine orders for blood tests, and I would mark a box for whatever blood test it was, or a routine for urinalysis.
Okay, but these 6 patients, even the ones that you did those things on, that wasn't actually billed for, instead of these other really high-level codes were added on.
Again, in the coding, I was actually not real privy of actually doing the coding. I was just told this is what I'm supposed to do. So I understand what you're saying. Like, I believe one was the speech and swallowing. So the way that it was explained to me is that, and which I should have researched, but it was explained to me that if there's a high risk of someone that has a stroke, or someone that maybe has a familial history of diabetes, or they have high blood pressure, that these are some of the things that I should perform on the patient.
So was it suggested to you that you use certain codes?
No, it was suggested. It wasn't code based. That's what I'm saying. It was like, this is what I want you to do if these patients have this. If this patient has high blood pressure, then you do this. If this person has, a family history of diabetes, then you do this. So it wasn't like, we were discussing codes per se. It was just more, I guess, patient care oriented of what I was supposed to do when I'm examining these patients. And as far as the complexity the exam and things, I was not really aware of that until after my conviction. It didn't even occur to me that, maybe a neurologist should be doing the speech and swallowing. I thought that as a PA that I could do these type of speech and swallowing tests. So that's, I wasn't aware of actually the level of complexity.
So you felt like the exam that you were doing and the written record that you were submitting were the standard of care?
Well, no, I guess there wasn't really thought in that. It was, I guess my thinking at that time was that I was just providing care to people that needed it, and I was going about it the wrong way. That's basically my thought.
So then my other question, I'm just confused by it, maybe you can clarify. If someone was giving you an insurance card that wasn't their name,
right,
then in these patients that they're listing, how did you even know how to match up lab work to the patient? Because it would have been the wrong name.
The card, I guess whatever name that is, that's the actual name that I'm writing on the chart. That's the name that I'm writing for the test or whatever. So that's following that card. So
then were they getting the lab work there that same day?
yes, I had a phlebotomist, a lab phlebotomist with me at the time. That was actually the person that was in taking the patients and doing the cards, and they would actually do the, any cultures, any blood draws. They would be the ones. It would be done on that day.
So these glucoses that are high wouldn't have necessarily been even fasting because these patients are just coming in and you haven't told them to fast yet?
That's correct.
Okay. And so then how were you getting a hold of these patients with their lab results? Did you ever call them?
No. I mean, really, when it got to that stage, it was really, I guess, just the total bad situation. My actions were just wrong. I didn't even think at that point I had any indications that I was going to see that patient again, because I kind of knew what the deal was, that they were actually not who they were, and they just wanted to be seen to get whatever they wanted from me at that time. And, I created false records.
So you said that you didn't financially benefit from this, but how were you just volunteering your time? Or
No, I mean, I was paid. I was definitely paid.
By, was it Dr. Sutton that
Yes.
was paying you? Okay, so Dr. Sutton was financially benefiting from this as well.
Yeah, oh, okay. I guess I misinterpreted. You mean when you say financially benefiting, I was thinking that you were talking about like, just so tons of money coming in or whatever, but we were paid by seeing the patients. So, whatever I guess came in, our agreement was that I get a portion and he would get a portion, and then we would have to pay our employees or whatever.
So whatever billed charges were coming in, then it would be allocated at a certain percentage?
Yeah, from our agreement going in, we had a split. Like, I think it was like 60-40 or something like that of the revenue that we would get afterwards. So, yeah, I mean, in that sense, yeah, we benefited.
Okay, that's all my questions.
Member Alexander.
Hi, good morning. Did you traveled here today from South Carolina?
Yes, sir.
Okay. I was just curious to learn how long did you work for Dr. Sutton?
About 5 months, 6 months.
5 months. How would you characterize your relationship with him?
Actually, I met Dr. Sutton while I was going through my program as a physician assistant, and really we weren't steadily in contact, but we knew of one another. So again, as my business with my other doctors was going down, I actually was looking to see if any other doctors I could work with to do these fairs or whatever. So I reached out to Dr. Sutton and told him what I wanted to do or whatever, and he agreed to come in and supervise me.
Okay, thank you. So it was after this 5 months, that's when you ran into the problem, I would take, after the 5 months working with Dr. Sutton?
No, it was during the 5 months that happened. So it was actually towards the end of the 5 months, like I guess probably the last 2 months when things just really got kind of out of hand.
All right. I was also curious about your letters. I mean, you have letters from physicians that you knew and your wife knew. I'm wondering why no letters from previous employers up until this point.
I'm not really in contact with them, and actually I reached out to these people because our relationship, I think aside from Dr. Greer, was not what I would deem long enough to actually even consider them really someone that I would ask for a reference. I don't know their whereabouts. I don't know where they're at. And the doctors that I have provided the letters from would be more knowledgeable of who I am as a person. So that's.
What about, just out of curiosity, any reference letters from folks that you worked with in South Carolina? Any employers? Or?
I didn't submit those letters, but I was following actually instructions of the petition, the reinstatement, and I was actually following that to the T. So they requested that I give the physician letters, and among other things, and that's what I did. I just followed the steps in that process.
So how capable do you feel right now of returning to being a PA?
I feel very capable. I feel as capable. I'm not deluding myself. I know that my skills are not what they were when I was practicing. However, I do feel that I'm as capable as a new grad. I definitely know I'm no less capable than the person coming out of a school right now. So I believe that if I can demonstrate that I can successfully pass the national board exam, I believe I should be able to have a second chance.
Okay, thank you.
Thank you.
Dr. Bishop.
I think the crux of the matter to me is that your prior offense was one of dishonesty. At least that's what you're convicted of. And the people that take care of patients have to be impeccable with their honesty. You have to, they're giving their full trust to you, and you have to be honest. And my concern is you continue to paint this picture that you were a somewhat unwitting participant in this whole scam, because it's a pretty standard scam that's used. You go out to underserved people and you solicit, you pay them oftentimes even to come in and just be there and act as a pawn so you can bill for them. And I keep hearing you kind of dancing around this again and again. And I just, do you still want me to believe that you really didn't know what you were doing when you were doing this? I mean, I know you may have started off with some sense of honesty, but it sounds like you pretty much knew what was going on. I mean, you're checking off boxes you did not, you knew what they meant. You had people you never expected to see again. I just want to make sure that you really understand what happened and what your part in this was, because if I can't trust you to take care of patients, I think you're not worthy of a reinstatement. And I think I have to be convinced. I keep hearing you unwilling to fully admit. I don't believe there's any double jeopardy at this point to admit that, yes, this is what happened. So I just want to leave that to you.
Okay, so I don't agree with what you just said. And I submit to you that in my statement that I read, that I said that I was convicted because I knowingly allowed patients to use medical insurance cards that weren't their own, and that I created false records. So from that, I don't see any dancing at all. You know, I'm being very straightforward. That whole event was totally wrong. It's something that I'm very embarrassed about, and maybe the dancing comes from that I'm ashamed to talk about it. So maybe that's what you're interpreting. But I am admitting that I did something terribly wrong. And I'm also submitting that I believe everyone deserves a second chance. I think that, I paid my debt there. I did something wrong, and I don't deserve to continually be punished for that, since I've already paid my debt. So I think I understand your concern, and I appreciate it. I am being very honest when I say what I say. It's not a point of me dancing around it. It's a point of me being ashamed of it.
Thank you very much. No more questions.
I just have a couple of questions. Did I understand you correctly to say that your purpose in requesting reinstatement of your license is so that you could sit for the NCCPA exam?
Actually, to practice as a physician assistant, but I was under the impression that I needed to be reinstated in order to sit for the exam. I mean, I haven't really investigated it to the point, but I remember when I went through school, in order to sit for the exam, I had to actually finish my school and be accepted by the board in order to sit for exam. So I don't know if any person can just go in and actually take that test. So it's my assumption that I have to be reinstated, or I have to have the blessing of the board in order to take the test. That's my understanding.
Okay, but you don't intend to live or practice in California, is that?
I didn't say that. I said I
That's
don't
what I'm
know.
asking you.
No, I don't know at this point.
You're
I
not
have
sure.
business. I still have business here. Again, I've only been removed since 2012, and that was actually the end of 2012 when my wife needed me to leave. And actually, I'm with her parents right now and helping them out.
So if your license were to be reinstated, you would be practicing in California?
At this point, I'm not sure, sir.
Okay, but maybe?
Yes.
Okay. When you submitted the super bill, were there any codes on it whatsoever, or was it simply a description of services?
I believe there's codes. There's written numbers on there.
And at the other places that you worked, when you submitted super bills or you saw patients, were there codes on those documents?
Yes, sir.
So would you say it was part of your usual and customary practice to mark codes that reflected what you did with patients?
Yes, sir.
And did I understand you correctly when you said that for these particular patients that you saw in the health fair, that you didn't understand what the codes were?
No, I said that I didn't understand the extent of the complexity of the codes, like say what she was mentioning about certain codes, the level of complexity and things like that. The certain codes that I was checking off during the time that I was performing the exams after my conviction, or during my conviction, or not actually during my trial, when the prosecution would bring these things up, I would be understanding more. So these types of things would be done by maybe a neurologist or whatever. At the time that I was actually doing them, I was under the assumption that I could do those tests, that I would be able to do them.
Okay, so if I understood correctly, you said earlier that you had no part in billing. I think you said it wasn't part of billing.
I didn't do the actual billing.
But you did check off the super bill for which the billing is generated, correct?
Yes, sir.
Okay. Would you say that the care that you provided to these patients at these health fairs was the same care that you provided to other patients that you saw in your practices at PA?
Probably not.
How was it different?
Those patients that are seen in the office, I have the equipment that I need or whatever to do. These were more, I guess, grossly done. So I would say no, they probably weren't.
Okay.
My last question is, if your license were to be reinstated, what assurances do we have that you would provide appropriate care to patients and that you would not participate in billing practices like you were involved with in the past?
Well, the first one is that I don't want to be here again. I don't want, what is it, 12 years of my life turned upside down. I guess that's the biggest deterrent. The next thing is that I think that was really more so, like I said, more of a situational thing that was occurring during my life, and I made poor decisions. I had a business that actually was affording me to have a certain lifestyle to provide for my family. That business was going under. I needed to do something, and I just did things that just weren't ethical. And actually, I think that's just a moment. I'm definitely, in my estimation of myself, I'm not that person. I'm not a dishonest person. I believe that it just was a situation that I got caught up into, and that I made poor decisions, and I didn't really even understand at that time that it would be leading to all of this. Like I think if anyone would have had the foresight of all of this going on, I may have made better decisions.
Thank you.
You're welcome.
Member Martinez.
I had some questions on billing, but I think they've been answered enough times.
Thank you. Member Diaz. My questions have been answered. Any further questions from any members? Any further questions from the Deputy Attorney General?
No, Your Honor.
You may make a summing up.
The board's primary concern in this case is the public safety. That's the one factor that goes beyond all the other factors and can outweigh any other calculus of the different criteria to be considered. In this instance, the public would not be well served and would instead be placed in jeopardy by the reinstatement of Mr. Hicks. There are two reasons. The first is the moral character and the moral fitness, and then the other would be the professional ability. And both of those go hand in hand in terms of providing safe and appropriate medical care. In this instance, Mr. Hicks has indicated that he is accepting responsibility for what's occurred, but his statements are the same, and we can't go back in time and be there, but it sounds very much like the same kinds of arguments that would have been made at the criminal trial, meaning that a lack of knowledge, and it was rather negligence and being caught up in a situation. In fact, even here today, Mr. Hicks has said that he was providing care for people that needed it, but that he felt he was just going about it the wrong way. That is an argument that the jury explicitly rejected in convicting him and finding him guilty of theft and fraud. Because the reason we know that is if you look at the code section that he was convicted of, Penal Code Section 550A5, the elements of that is to knowingly prepare, make, or subscribe any writing with the intent to use or present it or allow it to be presented in support of any false or fraudulent claim. Meaning in order to have the convictions that Mr. Hicks has, 12 people had to unanimously agree that he intended to submit this for the purpose of fraud. Even here today, he denied that he was profiting initially. He, upon further questioning, acknowledged that yes, he was being paid, but the purpose of fraud is to try to make money. The purpose of theft, the other conviction that he has, is to take something that does not belong to you. And that's the primary basis of what occurred. And that is something that Mr. Hicks is still, from the way he spoke today, he's having difficulty coming to grips with and acknowledging. That's the primary and the first step in any form of rehabilitation, is acknowledging what actually occurred. And so until and unless that occurs, the rehabilitation necessary to support his moral fitness to practice medicine and to take on that trust and responsibility with patients has not been established. And then the second issue is his professional ability, and he has made efforts to maintain his knowledge and education, and he continues to do that, and he's presented some documents demonstrating that. However, There is no evidence of his professional ability when he was practicing, which is the primary consideration the board would want to consider before determining whether, if they reinstated him, that he would in fact be able to safely and appropriately practice as a physician assistant. And so for these reasons, the Attorney General's office opposes reinstating Mr. Hicks' physician's assistant license.
Mr. Hicks.
I think I've been very forthcoming in admitting my wrongs. I don't know how many other ways I can say that I was wrong and my actions were wrong, and that I did knowingly allow patients to use cards that weren't theirs, and I created false records. As far as my professional abilities, no, I had no actions against me as far as a patient, malpractice or negligence in the patients during my time that I was practicing as a physician assistant. I did pass recertification examination during that period. Other than that, I would just ask the court to consider that that at this point, I mean, I'm having to defend something that's already done. It's already set and said, and so during my reinstatement letter, it stated that I should not re-argue the case. So I'm finding myself still having to explain things in a way, and when I explain them, then it's brought up like I have to actually defend it when it's already set in stone. So I guess my point is that I've admitted that I've done wrong, and I've actually taken one step further and to say that, okay, I've done this wrong, but this is what I've done since that point to rehabilitate myself, to actually deserve a second chance. And I don't want to be punished unfairly for something that I've actually worked towards trying to erase. I've paid my debt to society. I've done all the steps that were asked of me and now I'm looking for a chance to actually take that step further and show that I am capable to do a good job as a physician assistant, that I can actually be trusted, that I can be someone that actually will be an asset to whatever practice that I'm going to be in. Again, my nature is one of service. My character is such that I do like to help people. I have made poor decisions in the past. However, this decision this action that I took in 2000 is something that I've tried to erase, tried to get past, and I'm understanding that it's this court's responsibility to prevent any harm going to the public. I'm saying now that I feel that I am not a threat to the public. I feel that if I am given a second chance, that I will be able to take the step to show all the things that I'm saying today, that I am a person that is capable of delivering appropriate care to a patient, that I am honest, that I can be I guess trusted in order to do the right thing. And I did make a mistake back then. I just want the court to know that I am saying that I made that mistake. I'm not trying to dance. It's just something that's embarrassing. It's very hard to deal with. As she said, it is very hard for me to keep living that over and over and over and over and over. I don't want that to be a part of me anymore. I want to go beyond that. And so, I don't know if I can go any further than to say the things that I've expressed to this court and to this board. I've said that I've done wrong. I've done the things that I said. As far as all of the nuances in there, if I'm not answering them so readily, it's because that I'm embarrassed by them. I was convicted. I was sentenced. I had my probation, but with all of that, I went through all of that completed. I haven't had any trouble with the law. I've tried my best to keep myself current with the medical practices, and I know that that is always going to be a part of me, but it's not something that I want to actually just be the part that everybody recognizes, that I'm described by that incident, by my actions on that time. I don't want that. I don't want to be that person. I want to be the person that I truly am, and that person is someone that does deserve a second chance, does deserve to be a physician assistant again. And that's what I want to submit to the court.
Thank you. Any further questions or comments by anyone on the board? Anything further, Ms. O'Carroll?
No, Your
on matters submitted?
Yes, Your Honor.
All right. The board will be going into closed session to do their deliberations. You will not be getting a decision today, but sometime in the future you will be getting a written decision. The matter has been submitted, the record is closed, and we are off the record.
All right, I'd like to call the Physician Assistant Board back into order. We are going to skip down to agenda item number 16, which is the Legislative Committee report, Catherine Hazelton and Sonia Early.
Thank you. We've just passed out a sheet with updates on or handout with updates on the bills that the board considered in May. The final column of each of these sheets is an update as to where the bill is now. You'll see, for instance, on the first one, AB 1702, that the bill has been sent to the governor for signature. We're currently at the end of the legislative session. There's about a week and a half left in the legislative session, so most bills at this point are either being sent to the governor, are clearly dead, or are on the floor of the Senate or Assembly for final approval. And you'll see that throughout a number of these bills. I wanted just to highlight the 4 bills for which this committee sent letters to the legislature and discuss those briefly, and then if anyone wants to flag any others, we can certainly discuss those. So we'd skip forward to AB 1841, which was the bill that would allow medical assistants to distribute to patients prescription drugs. And this committee this board had a number of concerns about that bill, made several recommendations. Those recommendations were submitted recently to the legislature. The bill had already advanced quite a bit through the legislative process. What the board's concerns are most likely to have potential impact on the governor's office as he considers whether or not to sign the bill. I'm wondering if we want to have any additional discussion on this one. I wasn't sure if you had.
No, I mean, I looked at what the amendments were, and they seem to have addressed the concerns that the board raised last time, unless you felt differently. I mean, it seemed like that they were narrowing the scope of the bill to, I think, ambulatory surgical facilities and nonprofit community clinics.
I didn't feel differently, actually.
Oh,
There
you
may have
didn't
been a
feel
miscommunication here. I thought the
Okay.
instruction was from you that you thought that they didn't fully
I thought they had
didn't fully address the concerns.
I thought they amended it
They
after our
did.
last meeting.
They did amend it after
Right.
the last meeting, and I understood that there's still, or what I had understood was from that you had some continued concerns, but maybe
Oh,
that was.
really?
Yes,
Oh.
you did.
I did have continued concerns.
You had stated.
When?
You had stated that you believed that the change was not an affirmative statement of technical services, to not include consultation.
Oh, I thought that that had been corrected from the last meeting. I'm sorry. Because the last amendment was June 2nd, which was after our last meeting, right? So they amended it to include, to narrow the scope of the services to outpatient ambulatory surgical care clinics, nonprofit clinics, community care clinics. Yeah.
And it didn't address, I think, what was the key concern of this board, which was that they didn't want any consultation from the medical assistant to the patient. So I think that's what remained the concern.
Okay. I thought the last time, though, that it actually said that they were doing the consultation. But I think okay. Sorry.
Oh, no, that's okay. So at this point, there's not much opportunity for amendments from the legislature. I think we would see this as an up or down vote from the governor. Having said that, I do think that the amendments, will assuage some of the concerns, and I didn't see this bill as a major concern to the board at this
So
time.
the only amendment is from last time is just the narrowing of the scope to the clinics. Is that all that changed, or what changed?
That's all that I understand has changed.
Okay. All right.
Okay, moving on to AB 2058. This is the bill that would require all committees of any board, such as our board, all committees of 2 board members or more, to be subject to the open meetings law, which would mean that, for instance, if this legislative committee of Sonia and myself wanted to discuss a handout such as this over email, that we would actually have to have a publicly noticed meeting in order to do so. The board sent a letter to the legislature opposing the bill. The legislature did acknowledge the board's concerns and did include in subsequent analyses of the bill the board's concerns, including what I believe the board estimated to be the cost of implementing the bill. And it's interesting seeing they included the cost from a number of boards of what it would be to implement the bill. From our board in particular, they had the figure of $13,000. And I could imagine the way that it was written, it seemed to indicate that these were negligible costs that should not be of concern to the legislature, although anyone looking at the budget of this board might think otherwise. So it was, the concerns of this board were acknowledged, but I don't think that weighed very heavily on the legislature's decision to pass the bill through unanimously, and it's now, I believe it's now on to the governor.
The concerns did make its way to the governor's office, though.
Mm-hmm.
So, I mean, the fact that the board took a position, I think, is very helpful to the governor, so the governor's aware of what the boards feel.
Mm-hmm.
And this was not the only board that opposed the bill. I know other boards in the department had also significant costs, and that was conveyed. And so the department has taken an opposed position on this bill.
Mm-hmm.
So that's a good sign for this board.
Mm-hmm. And that was is a recent position?
Yes.
Mm-hmm.
So.
And just to note, this bill is actually back in the Assembly for concurrence, but it will likely be sent to the governor soon with those notifications. Moving on, skipping past a few of these, down to SB 1083, which would authorize PAs to certify claims for disability insurance. The board took a position in support of this legislation. The bill has passed the Senate and the committees in the Assembly. It's now awaiting a vote on the Assembly floor. It looks likely that it would move on to the governor's office. And finally, there was another bill similar to the open meetings notice that we just discussed that would require state agencies to notice the public 15 days in advance of any, of any publication of notices of proposed regulatory action. So it would back up the dating of our materials for our meetings another 2 weeks. We sent a letter opposing the bill. The bill was held in Senate appropriation, so it's effectively dead. Are there any other bills that we looked at previously that anyone would like to discuss? Okay, thank you very much. Oh, is public comment? No? Or maybe?
I'd like
Quick public comment.
Kappa comment on 1083, because it actually did go to the governor's office.
Yes, thank you. Teresa Anderson with California Academy of Physician Assistants. And first I'd like to ask if you have specific questions about the bill, because I know there was some back and forth with it.
1083?
Yeah.
That's the disability insurance.
Mhm.
So.
Yeah, I think we'd heard rumors that, was it DGS, Department of General Services, that had problems with it?
It was the Employment
Or
Development
EDD, sorry.
Department. Yeah.
Employment Development Department.
Had some late concern about the cost of the bill, so we were working with the EDD to look at some of the costs. And the cost, I think part of it was just a misinterpretation of how to verify the PA has, would be able to certify disability insurance. So now, we've come to an agreement on that DSAs don't have to be, looked at each and every time. That it's really a delegated service like anything else. Like they, wouldn't call DMV to find out or verify that the PA was authorized to do a DMV physical or something like that.
Is the author trying to discuss with disability about the huge number that they piled on to implement the bill?
The original figure that came back was $4.6 million. So we were a little bit taken back by that. Felt like a very large number. And part of that was based on the fact that the interpretation was that they would have to look at the DSAs each time. Once we explained that, how that works, then the cost came down to $3.9 million, which is still a significant amount of money, but their costs come from testing, inputting the PA licenses and numbers and verifying active and current license, as well as testing software and that type of stuff. So at this point, it's an IT cost. And I would like to note that there was never any problem policy-wise. The bill has had, a remarkably warm reception on the policy end of it. And on top of that, SB 770 was chaptered. That was a bill last year, and it became effective July 1st this year. They expanded the pool of eligible people for paid family leave. So, that's going to increase the number of people seeking this benefit and really just delay access to benefits, in offices where we, our PAs really need to be able to sign these. So we're definitely, the bill came off suspense yesterday. Last week, and was heard today in the second reading. Not heard, it was second reading, and it will move forward be heard on the floor, and then we'll be able to work on it a little bit more as it moves forward. So, any questions? Thank you.
Thank you.
Before we move on, I did want to ask about AB 2058, which is the bill related to the Open Meetings Act for committee members. If that bill is signed into law, we would like for that to be as an agenda item on our next agenda for how we should think about any committees on the board and staff responsibilities and how those might shift. Thank you.
Okay. Anything else from the legislative committee? Okay, thank you. We will now go back to agenda item number 13, discussion of accreditation, physician assistant programs accreditation process. I keep putting this on the agenda because I have real concerns with ARC and their lack of response pertaining to anything that comes from just about any organization as to what's going on. They're now taking over 2 years to approve new programs. We're in a real crisis in California, needing a few thousand more PAs, and we just got a program approved that's going to graduate 24 in 29 months. So I just would like to hear other members of the boards and their opinion as to if and what we should be doing anything with the ARC.
Mr. Sachs, I don't know how much pull we have with the ARC, but I'm just wondering, looking at a different tact, although we can't accredit new programs very quickly, can we expand the existing ones? Is there any infrastructure for helping to expand those programs to include more students each year? It may require looking for clinical opportunities for them, but just classroom work is relatively independent of class size up to a certain point. You can go from 24 to 48 without too much trouble. It's just the clinical facilities. So we might look into where these students could get clinical training. I mean, a lot of the smaller medical schools and such in different states send their students off to different places to get that. So if we're really stuck behind the 8 ball, we might consider just expanding the ones we have.
Judd, do you have any thoughts?
Yeah, the ARCPA is really the only accreditation game in town for PA training. I'm not aware of any other accrediting body for PA schools. And unfortunately, what that means is that they sort of have a monopoly on the market, and someone who wants to open a training program or do anything training PAs really has no other options. It's my understanding, if I'm correct, that California can approve its own PA training programs, but that we accept ARC accreditation as acceptable for us. The question is, if California were to approve its own PA programs to address the shortage of providers in the state, how would those graduates become certified? Because the NCCPA doesn't accept non-ARC PA accredited program graduates to sit for the boards. And how would those people get paid? Because a lot of Medicaid, Medi-Cal here, Medicare and government facilities, those sorts of things, require, in order to credential, having graduated from an ARCPA accredited program. So all of those things sort of conspire together to make them the only game in town, which is problematic when you wish to get some traction with them. So I don't know what the resolution is, but I agree with you that there is a concern there. And I'm certainly open to exploring what options there are. But it would appear to me that anytime you try to make changes, there's unforeseen consequences to those changes. And so trying to look down the road and anticipate difficulties in sort of figuring out how to circumvent the ARCPA or to find another means of accreditation for PA training is fraught with unintended consequences and difficulties. So I certainly am supportive of training more folks, but I'm not sure how to do that.
Would it be beneficial to invite somebody from the ARC to attend one of our meetings?
Absolutely. I would think so.
I would agree. I would agree. I think we should invite them.
Bob, Bob. That was one of my concerns, really, regardless of what we choose to do in terms of exploring other options. It seems like the communication has not been flowing. Didn't we initially make some attempts to communicate with them some of our concerns? Have we written them a letter? And
we did a few years ago, and the response was not very pleasant.
And I think that needs to be something that we need to ensure that there's some accountability there for our consumers. So I don't know if that means exploring an option of talking to other boards who may have, or other areas who are also dependent on their certification, if it comes to leveraging their voices with ours about engaging in better dialogue. But I do think that we need to pursue this avenue of better communication, regardless of whether or not we explore other options.
And we may want to direct the executive officer to send a letter inviting them to a board meeting to address some of our concerns about the length of time of new program certification. The other thing I think we discussed once before that I think might be a potential benefit is to find out there has to be member organizations of the ARC. I mean, there has to be another level that approves the ARC to be what they are. And we probably should explore and see who those agencies are and maybe forward some letters to those agencies about our concerns. Maybe that would give us a little bit more leverage.
Isn't it the Department of Education? Don't they accredit?
I think it is. It's an organization.
It's the Department of Education.
Because they can't get, if they don't get their approval, then they can't get grants and loan monies at the schools and educational providers that provide their programs.
So maybe if we communicated with them, there were issues, could be a two-pronged approach. I would be interested in seeing what their response would be to being invited to come and address this board. I keep it on them. It's almost on every agenda. I'm beating a dead horse. Let's go to item number 14, Medical Board of California activities. Dr. Bishop.
Yes, we do have activities, thank you. I don't have anything prepared. We had another prescribing task force meeting. It would be the second meeting. We had more input from the stakeholders, and so at that meeting, with my usual aplomb, I had vocal gaffes, but I did convince everyone we were going to have a third meeting with stakeholders, and we anticipate that this will be the last meeting where we will be able to address all relevant concerns and be able to produce a final product hopefully soon after that. But as of yet, I haven't received any notice from our staff as to when that meeting might be taking place. But there will be a third meeting, and that should be hopefully the final one.
Okay. Any questions for Dr. Bishop? Public comment? All right, thank you. We will go to item number 15, budget update. Diane's going to tell us how much money we have left.
Yes, actually, the report does tell you. The CalSTARS, the first 4 pages are month 13, which is the end of the fiscal year. And if you look to the page 4, we ended up with 10.63% of our budget left over. But, however, keeping in mind that we did have 2 positions. First, Glenn's old position was left vacant before Lynn filled it, and then Lynn's position. So we're still good, but we are close. So we will keep a close eye on our budget for this year. The next one was kind of the projection, but this was done before we received the month 13. So we thought we'd get about 13.2 left over, so we have a little more. And then the last page is a projection just for the next fiscal year, the months in reserve, and we anticipate we will have stay right around the 10-month, actually growing a tad. Now that we have month 13, with the next meeting, we can push it out a couple, 3 years and see where we're going to be. So we ended up quite well, but we will have to keep an eye on everything because of the possibility of being really close this next year.
Okay.
Questions?
Board members have questions? Xavier, this is up your line.
I had some questions earlier. They were explaining. I was curious why there's negative amounts in the balances, but that was already explained to me. But again, being on a budget review committee, municipality, I'm looking at different items, and I see negative amounts, but there's nothing in the budget. Excuse me. I see negative amounts, but there's nothing in the budget coming across, so I was just curious how those items are developed.
They're developed by the department, and at the time, I believe, the 418.02 is the Sures, I think. So some of it was added afterwards. So I think it's the Cures report is the 418 if you're looking under the external services.
I'll just give you an example, like under staff benefits, item 134, there's a year-to-date 8,838, and balance is a negative, so there's nothing in the budget. The first column.
Correct. I'm not sure what the other staff benefits are, to be very honest with you. I don't know if that's, I don't know what those are, because we don't put in the budget for any of the staff salaries. I can have our budget analyst from the department. He could come to our next meeting. I can ask Wilbert
Okay.
to present how this is developed. We'll have our new budget for the following, for the next fiscal year, but I can certainly have Wilbert Lamboa from the Department of Consumer Affairs, how this is actually, the budget is determined.
Okay, thank you.
Mm-hmm.
I have a question about the printing costs. 96% negative. Am I understanding that right? What's I only ask because we got a giant pile of paper today.
Well, actually, all of that was not, that was from Metro, which was the new mailing
Breeze.
services from Breeze.
Oh.
They mail out letters, they mail out our renewal notices, the
renewals.
certificates, and that is the cost from the new Breeze system.
That seems expensive.
I'm glad that you raised that, though. I was actually going to ask Lynn about paper and see if we could possibly get electronic copies of some of this stuff in the future. I do notice that you've got there's also more used on copier expenses here than was budgeted for. So I don't know if it's something you'd be interested in doing, but if you want to survey members to see who'd like electronic records, if that's easy for you. Some of us may want to sign up for that.
Do we have to have a paper copy, don't we, Christy? Or can we do electronic?
Did we order a transcript? Did that come through USB stick?
Yeah, I think that when you order transcripts from the Office of Administrative Hearings, you can get an electronic copy of them.
Or we get one copy and make it electronic.
Yeah.
Because it would certainly be a lot less expensive to send a USB stick, number one, and number two, rather than lugging all of that paperwork up here, it would be on a stick, and number three, we could read it anywhere that we were at because the stick would be in our pocket rather than
Yeah,
400 pieces of paper.
I know that years ago when I asked for things to be put on a flash drive, I was told there weren't no secure flash drives. So I don't know whether that policy's changed or not with the department.
The
But
medical board does it extensively, so they may have.
okay, maybe you not confer with them about it, but I know I got pushback on the flash drive issue for confidential stuff. Now, for non-confidential, like transcripts or the board packet, that's the public portions of the packet would probably not be a problem. But when you're dealing with like the closed session items and stuff, that's the part that we have to be really, really careful about.
We do receive those
So-
via email in between meetings, so perhaps we could receive those via email for the meetings as well.
Yeah, like I said, I'm just not sure what every board's different policy on that. Some people don't like to email people that stuff for the board meeting, but I don't know, you'll have to look into the security policy for the department and see on that part. But of course, on the public portions, there shouldn't be an issue.
Okay, good.
Does everybody want an electronic copy? That's the question.
I'd love a link to it, not even on a flash drive. Just email me a link.
Yeah. All right, okay.
So the staff are not going to do these binders anymore.
Well, we should be sure that if there's anyone who still wants it.
At the medical board, some people, they're given the option.
Yeah.
Some people still really prefer the packets, other people prefer the thumb drives.
Since we have 13% left over, we could buy Apple laptops for everybody.
Yeah.
Including our
Start
attorney.
with square one.
That'd be nice.
We'd
I
say
can't-
with
they won't buy
postage.
one for my office, so we can't get them in our office. I haven't been able to get them, so.
Perhaps staff could explore options and present some options to board members.
Anything else for
I had one more that kind of stuck out like a sore thumb, was on services external, line 418.
Correct.
$73,000 of consulting professional services, and there's nothing in the budget.
Here again, it's Breeze related, our
Okay.
new electronic system. And those are costs that are,
For the programmers and
right,
okay.
The contract.
the contracts for Breeze.
It's the Breeze follower.
The Breeze, our new Breeze.
Okay, thank you.
Okay, is there any public comment? Okay, we will move on to item number 17, agenda items for the next meeting. Okay, so we're going to have a report regarding the ARC.
Nominations and elections for
Okay.
officers. We're going to approve the passing score for the PA exam and the exam dates, and it should be 2015. And meeting dates for 2015.
Okay.
Review the policy manual. If AB 2058 passes, how we will comply. We're going to have the budget, Wilbur. And we'd like to have the hearing for the 1399.523, the disciplinary guidelines.
Wow,
You know
it's a
what?
big agenda.
Okay.
Consider we have a lot of closed session to deal with too, so.
Well,
I'm up for it if you are.
Anybody have any other items for the agenda? And once again, any member can send an agenda item to the staff and it will get put on the agenda.
I'm not quite sure if this was the last item you said. I don't think it was. We had talked about the manual for guidance to board members. Is that what you were just
yes,
talking about there?
the
For
policy manual.
Okay.
We'll include that.
Further discussion?
Are we meeting at the same time next? Earlier, 8 o'clock?
Public comment on any of the items we've discussed? All right, there being none,